Uh, Good morning. Send it to.
Five, three, two.
Champion.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor.
Good morning. How are you?
Good. I have two ladies over here for Miss McLeod. I am ready to start whenever you are.
All right. Is she on? I can't
Yes.
see everybody yet.
Judge,
Good morning.
good morning, Judge. As it pertains to position 6, Ms. Bell has several cases. That case I was appointed on June 6th, but I do see that Ms. McLeod represents her in the majority of the cases. So I'm waiting for Maureen to jump on, and I'll just kind of hand the ball to her.
Okay.
Thank
Gotcha.
you.
There she goes.
And yes, I did go to, I am representing her. She is on. I have spoken to her. I saw her yesterday. We've been in contact.
All right.
And, it's best if we handle all of these cases together.
Is the state here?
Good morning, Your Honor.
Good morning. All right, we ready?
Yes, Your Honor, we are.
All right, ACDC, what positions again?
Ms. Bell, position 5 through 8.
All right. First case I have is 26 CR 0000625C. Ms. Bell, in that case, it's 1 count of battery family violence. Position 6, ending in 3663C, disorderly conduct. Position 7, ending, well, that's an FTA, ending in 1028. And then position 8 is 25 CR 0003547C, 1 count of battery, 2nd count of simple battery. So that should be all of the positions.
Your Honor, I am asking for Miss Bell that the FDA be dismissed. I have searched through the cases. There's no evidence that she has ever FTA'd on any of these cases. As a matter of fact, Your Honor, I was in court for Miss Bell on June 11. She was supposed to be taken over to the courthouse, and she was not taken. When I asked the deputies, they said she just wasn't taken. But if you look in the cases, Your Honor, there is no evidence that she ever failed to appear on any of her outstanding cases. Miss Bell is only 23 years old, Your Honor. She has absolutely no criminal convictions at all. She is the mother of a 1-year-old child, and she's anxious to get home so she can take care of her child. On the 11th, the alleged victim, who is a cross victim because both of them were arrested, and they are the parents of this little child, was in court. He was not in jail, and he indicated to his attorney that he did not want to testify against my client. They have both filed Fifth Amendment affidavits into that case. Therefore, she should not be taking a plea just to get out of jail, Your Honor, when she did not, in fact, FTA on anything. What I'm asking for is for the FTA to be dismissed so that she can get out of jail and properly address these cases. She shouldn't have to address them under pressure. In one of the other cases, she actually has a diversion pending, and she is not in default under this diversion. Therefore, to ask her to plead to these cases so that she can have a record just does not seem to be fair, given the fact that there is no evidence that she failed to appear for anything.
All right, so you're asking for a bond?
That is correct, Your Honor. I'm asking for the FDA to be lifted so that she can get out of jail.
Well, I don't have any information on the FTA. Let me hear from the state. What do you have on the FTA?
Judge, you'll have to give me a moment. Odyssey is not my friend already this morning. So
Okay.
I'm trying to look up the information. I anticipated in my communication with Ms. McLeod that we were going to enter into plea today. So just give me a moment if you don't mind.
Okay.
Does the
And
FTA
Your Honor, I would also like to say that the same situation occurred on Tuesday. I had another client who was sitting in jail on an FTA when he did not, in fact, fail to appear for anything. So I don't know if there's some kind of glitch in the system at the jail or what it is, but this is the second time this week that this has happened. There is nothing in any of her cases saying that she failed to appear for anything.
All right. Good morning, Mr. Jordan.
Good morning, Judge. So this FTA is a pretrial bench warrant. So pretrial is basically surrendering the bond, and they ask the judge to issue a warrant. And the warrant was signed by Judge Morrow. Same thing with the case on Tuesday. If the people are not complying with the conditions of their pretrial release, pretrial is asking the judges to issue a warrant, and they are coming off of the bond.
So their pretrial,
Correct. It's a
the
pretrial
rendering
warrant
bonds.
that was signed on April the 10th by Judge Morrow.
So usually it's them not reporting or doing whatever the
Correct.
conditions are they have to do through pretrial. Ms. McLeod was not showing up for a court date, it's reporting to pretrial.
I understand, Your Honor, but my client tells me that she has information in her phone showing that she has reported to pretrial, and she has in fact been in court on all of her court dates because I have been representing her. Pretrial did not reach out to me or to say anything that they hadn't seen my client or anything like that. And I just do not think that it is fair to her, Your Honor, to be sitting in jail on a failure to appear for pretrial when she's shown up for all her court dates. Nobody reached out to me to say, look, we haven't seen your client. And this has happened in the past where pretrial has reached out to me and they have said, well, we haven't seen your client. And I have been able to speak to my client and to find out what is going on, why they didn't show up for pretrial. So I'm asking Your Honor for a signature bond for her on this pretrial FTA so she can get out of jail to properly address her cases.
Let's see, Mr. Jordan, I don't know if we're, pretrial doesn't normally come to this,
Here, Your Honor. Was trying to
calendar.
look. Good morning,
Who's speaking?
Ms.
Oh,
Howard.
okay. Ms. Stallworth,
Hi.
I'm sorry. Look, good
That's
morning again. I just saw you.
I know. I was trying to look it up, but if you give me just a minute, I misplaced my
Okay,
phone so I
let's
can
look
see
it up.
see
Do
if
you
there are
all
some notes from the
right.
case manager.
Do you all know that you customarily, I know you have a lot of clients call the attorneys when they don't appear or don't show up?
Now, that I'm not sure of because that's under supervision, so I'm not sure if they contact the attorneys if that's customary, but they usually do put notes in Odyssey, so that's what I was trying to see, but I forgot how to pull it up. So if you give me just a minute.
Okay, okay. We'll let everybody do a little research for a second.
And I'm gonna have to go out and come back
I
in.
know that I have been called several times or emailed by pretrial to say, look, haven't seen your client. Do you know what's going on? Or tell your client they need to report.
Judge, Judge, on June 6th, when I argued for bond there was no mention of it at that point on her case, position 6. That was on June 6th, and nothing was mentioned at that time. And bond was set at 1,500 surety.
Hmm.
In fact, Your Honor, I believe you set that bond.
Did I? Okay.
And I would also like to point out, Your Honor, on that particular case, she is in diversion. At least that's what I see on Odyssey, in Odyssey. My aim here, Your Honor, is to protect this young lady's record, given the fact that she has no criminal history. I do not want her to have to take a plea just so she can get home to take care of her child. It just doesn't seem fair.
I get it, but I'd like to get some more information. I do understand what you're saying, but I don't want to just jump real quick and move without more information, either from pretrial or the state. I just want to hear what they were able to research and find out, just to be on the safe side. All of these cases came at the same, let's see, with different dates. June 4. No, the next one's March 24, June 8. February 1st, February 1st, June 4th, March 24th, and June 8th.
Hold on, they're coming. No, there is a 7 Southwest.
Were you still trying to get information? I'm sorry, I had to leave and come back on Bell.
I am.
Oh, okay then. I just didn't have anything to indicate that anything other than they were in diversion. There's nothing in the notes to say that she didn't appear or that she wasn't compliant with the diversion. I don't have any information as to that. I don't know if pretrial is willing to, if she's out on their release, if they're the ones who issued the warrant.
They did. You were gone. Mr. Jordan came in and said it was a pretrial warrant.
Okay,
And he said it was issued for the case ending in 625C, which is position 5.
okay.
I believe he made a correction, Your Honor, and said it was
Oh,
for
sorry. 4-8. I see that.
25. Yes.
It was for
So I think all of those cases are actually running together through diversion, is my understanding, just from looking at the record, so.
Yes. And Your Honor, I would like to add that had she been in court on the 11th, which she was actually in jail, and they didn't bring her, all those cases would have been resolved on that day. I was there. Everybody was there who needed to be there, except nobody brought my client. So it would have been a moot issue at this point because her case would have been resolved then. So I do not think that is her fault. She did nothing wrong with respect to resolution of the case. That is why I'm asking for her to have the opportunity to properly resolve these cases instead of being forced to take a plea in order to get out of jail to take care of her child.
And it does appear that she's been incarcerated since June the 5th of 2026.
That is correct. So if she could not have come to court on the 11th unless they took her because she was actually in jail.
That's right, because I represented her on Saturday the 6th. She was in
What
custody.
I'm showing in I'm
So that's
sorry.
pre-trial.
So she didn't report to pretrial on March 16th after court as instructed. And that's whenever they sent, they mailed out a letter to the last known address for the FTA.
Young lady, you finished? You finished. You come here.
I talked
Yeah,
about
Unless she
Pre-trial,
was
can you come back? All right, so what are you saying now?
So she did not report to court, to pretrial after court on March the 16th of 2026. And so after that, they mailed out an FTA letter to her last known address.
Okay, and my client tells me that she recently moved, so that could have been why she didn't even see this. Because
Did she
there was
update her
a
address?
cat. Yes, so she's given me the new address.
No, but did she give it to pretrial?
She probably didn't at the time. But I think she wants to say something. She tells me that she has a lot of records in her phone. Of course, she doesn't have access to the phone because she's in jail. But essentially, what I'm asking for is for her to be able to get out of jail, given the fact that she's certainly been compliant with the court. Sounds like she may have missed one reporting to pretrial, but she's certainly not missed any court appearances. So this is what I'm asking for her to receive a signature bond so she can get out of jail and then she can properly deal with these cases.
State, I don't know what your position is.
Well, I mean, normally if there's a bench warrant that's been issued, we would, defense would ask to set it aside. And I just, and normally if, it's for the first time that something like this happened, we would go ahead and the court would set it aside. I can, I'm not, pretrial issued the warrant. Are they taking her back? Would they be taking her back on their caseload? I guess is my question.
Pre-trial?
Yes, Your Honor. I'm sorry, I missed the question.
I was asking if the court were to issue a set aside on the bench warrant, would she be able to go back onto pretrial services?
Yes, it's per judge discretion.
Okay, so I'm not opposed for the court setting aside those FTAs. I guess I could just null process them as well. And then if she can go back on pretrial, I can do that.
Would be perfect.
Okay.
Then, Ms. Battle, you may want to, if you'd kindly consider a null process position 6, because that's the 1,500 surety. There was no signature bond on that one. I had argued for that, but due to her other cases, the judge had declined. So just putting that out there.
At the disorderly conduct?
Yes.
That is correct.
Okay, I had already indicated that I would null process that case anyway, so.
All right, duly noted. Then I'll mute.
Thank you.
Okay, Ms. Evans, it will be a null process for position 6 and position 7 for Ms. Bell. Is that my understanding? You're muted.
Yes, 6, 7.
And position number 5, we're gonna reset further notice, correct?
Correct, and position number 8.
Okay, all right, thank you.
Thank you, Your Honor. Thank you, Ms. Evans Battle.
So
Yes,
she already has bonds on those, correct?
She had signature bonds, I believe, on those other two. That's my
On the other two.
understanding.
Next, no, hang up. Next, come on, get attention. She's on the phone. Yes.
Are we done with Bill?
Right. Is this all we need?
I think Deputy Milton walked away from the camera.
Okay.
You can start in courtroom 2.
Courtroom 2?
You know what, I have one more for Attorney McLeod, position, Ms. Harris, position number 24, have a seat.
Right.
Okay. Put your hands down.
All right, this is 26 CR 003464J. Kiana Harris. And is this a plea? Or not? I don't know. Doesn't say.
No, Your Honor, it is not. There is no plea offer, first of all. My understanding is that this is going to be a felony transfer. That was what I saw in the offers. Now, Your Honor, I'm unsure what kind of bond she has because she's been sitting in jail for quite some time. So I would like to address the issue of her bond.
Your Honor and Ms. McLeod, I did send over an updated calendar. I'm not sure if you were on that list last night with an offer on this particular case as well as some other cases.
No, I did not receive it. So if you would just send me the offer and then maybe I can speak with her.
All right.
Okay.
Because that was the last thing I got was a felony transfer.
Do you want me to send it in the chat or email it?
That would, either way, it's good. And I would need to, of course, speak with her once I see it.
Okay.
I think email would be better. It's kind of a lot to chat.
Yes, send an email. Yes, that would be perfect. Thank
All
you.
right.
Yeah, and I guess we can deal with another case until
Okay. Let's speak with her.
I'm
Okay.
able to speak.
Thank you.
I'm doing number 14, Mr. Bernie.
Miss-
26 CR 003666Y, Robert Burney. Charged with 1 count of criminal trespass.
Negotiated.
Is this still gonna be a plea, Mr. White?
Yes, Judge.
Okay.
No, not yet. Just have to seat over there. Have a seat over there.
All right, state.
Yes, Your Honor. It's 12 months to serve, 8 days credit for time served, balance probated, a fine in the amount of $300. Stay away from the Echo Lodge at 4265 Shirley Drive. Complete 12 anger management classes. Restitution, we'd ask that it be held open 30 days for restitution and and we'd ask they stipulate to identity, venue, and a factual basis for the plea.
Judge, we do stipulate for the purpose of the plea. We would ask to waive 3 months of probation fee so that can be applied to the restitution, if any, and ask his probation to terminate once he completes all of his requirements.
I'm not going to waive 3 months of probation. I'll waive 1 month. And what is being held open for 30 days for the restitution amount?
Yes, for repair, receipt for the window.
Okay with that, Attorney White?
Yes,
Okay,
discussed it with Mr. Brown yesterday.
okay. All right, Mr. Bernie, I understand that you wish to plead guilty today. Is that correct?
Yes, ma'am.
All right, I'm gonna swear you in first and ask you a series of questions to make sure you understand your plea, all right?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. And the first question I have is, are you currently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding today?
No.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to a trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, correct?
Yes, ma'am.
Has anyone told you that you'd receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you do understand that if you're on probation, it could be affected by a guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of criminal trespass and damage to property, how do you plead?
Guilty.
All right. I will accept your guilty plea and your attorney explained to you the conditions and the restitution. So you understand all of that, correct?
Yes, ma'am.
All right. I will accept your plea and good luck to you.
Thank you.
Thank you, Your Honor.
Uh-huh.
All right, next we got 45 through 48, Mr. Perez.
And I'm sorry, Mr. White, he is, we were fine with terminating him after he completes the conditions, correct? Okay.
I'm fine with it.
I was gonna say, State, do you have any objection? I forgot to ask. All right. Who do we have next? I'm sorry, Deputy.
45 through 48, Mr. Perez.
Okay. All right, this is 25 CR 008403Y, Johnny Perez, charged 1 count of simple battery, family violence, and a simple battery against a person 65 or older, or who is pregnant. Position 46, 25 CR 008528Y. He's charged with 1 count of battery family violence, 1 count of simple battery family violence, and battery against a female who is pregnant. And position 47 is the 26 FTA 001003. And that's all that we have, right? All right. What are we doing today?
Judge, we're just maintaining a not guilty plea, asking for a jury trial, putting the state on notice that we will be filing a statutory speedy trial demand.
Okay.
And I wanted to see if on those position numbers he had a bond.
Let's see, Attorney Smith.
Thank you, Judge. And I apologize for my attire, Judge. I'm at my son's baseball game in Omaha.
Okay. Oh, I saw that on TV. So yes, I know who you're there for then.
Well, my son's 12. We did go to the game last night, but
Oh, you're okay. I thought maybe you played for Georgia.
no, I wish one day maybe.
One day, maybe inspire him to strive for that.
So, the bond
Mhm.
for Perez Okay, on the case ending and on position number 45,
Mhm.
the bond is a cash bond. It's a $3,000 cash bond. And they're not linked together, so I have to look them up separate.
I've got a $4,000 cash and then a 2,000 surety. I'm maybe double check, but that's,
Okay. Right, I have $1,000 surety on, that's position 45. And
So there's 45 for each of the separate, the 3,000 cash and the 1,000 surety, or? I'm confused.
so the cash bond is on position 46, and then the surety is on position 45. Well, there we go. Okay. Yes, $1,000 surety on position 45. That's
Okay.
what I have.
All right, is that what you had, Attorney Smith?
Yes, Judge. Thank you for checking on that. Thank you.
Okay, all right, you're welcome. And anything else that we need to take up today?
No, Judge. Appreciate the court's time. Thank you to everybody.
All right, thank you. All right,
Bye-bye.
bye-bye.
Judge, if we could go to position 36. 35 and 36 are the same defendant. Ms. McLeod represents him on position 35. There's some notes. Ms. Evans Battle, are you transferring that case 36?
Yes, we're looking at transfer of that case. I believe this is the first time it's on the calendar, so we would ask for at least a 1-week reset on it.
I want to address the issue of bond for Mr. Lope because I have been in contact with his family, specifically with his wife. His mother has died in Senegal, and she has told me that her husband needs to go to Senegal because of this. My client does not have a history at all, except he was arrested in May and charged with marijuana possession. Then he was recently arrested and the charge was disorderly conduct. To my surprise, he was given a $25,000 bond on a disorderly conduct charge. That just does not seem to be reasonable at all. And what he tells me, because we have spoken and what the wife told me, was that he was just giving away some clothing. He does that kind of thing. He does a lot of like philanthropic work. And I just saw the warrant and it says that he may have had like a knife in his hand or something, waving a knife or something. He denies that completely. So I am at my wits' end trying to figure out why someone who has absolutely no criminal convictions at all, and the only previous arrest was one for possession of marijuana, is sitting in jail on a $25,000 bond for a disorderly conduct. Make it make sense. I just don't understand it. As a matter of fact, when I was first told by the wife that that was his bond, I said that could not be. But I actually went back to check and I saw something is quite wrong with this picture. So therefore, I'm asking, quite frankly, for signature bond for this man. He doesn't have any criminal history at all. And he's sitting in jail. His mother is dead in Senegal. And he's just in jail on a $25,000 bond. I'm just trying to make sense of that.
Yes, Judge, I was there on June 6th, and that was ASG Evan Dudley had requested that, and the court granted that bond, alleging that there was some major chaotic event at a Burger King.
When was that, or do you see that, Mr. Jordan or Miss Evans battle?
Yes, I've just, if this is a bond hearing, I take it, then I'll, present the facts to the court.
Yes,
I'm not sure who was the judge on that particular day. Who set
it
the
was
bond.
Judge Lal, and
Okay.
I don't know what was said. I actually watched the proceeding myself. I went back and watched it, and I was like, I don't get it. There must be something in the warrant that I am missing. I looked at the warrant yesterday, and I saw absolutely nothing which would have $25,000 bond on a disorderly conduct for someone who has no criminal record. It doesn't make sense. So I'm asking for a signature bond for him. He doesn't have any record at all.
Right? Are you still looking?
No, I have the, our bond, what we call a cheat sheet that lays out what the facts are. June the 2nd, 2026, the officers went to a Burger King located at 5068 Old National Highway in College Park in reference to a person armed with a knife and involved in a disturbance at the location. The officers observed the defendant who matched the description that was given by dispatch. They did, for officer safety and further to de-escalate the situation, make contact with him and detained him. Then he was identified as Mr. Antoine Lope during the course of the investigation. The officer spoke with several witnesses, including the employees and bystanders who were present during the incident as well, and indicated that he had been in a dispute with another male, according to the statements. The argument escalated when Mr. Lope produced a knife and began swinging it at the other person in a threatening manner. The Burger King employees identified him, stated he was waving the knife, advancing toward the other person, fearing for his safety. The other person armed himself, picked up a shovel and was fleeing. The witness further stated that after the male left, Mr. Lope began walking toward the entrance while still holding the knife. Female employee observed him approaching the locked entrance door. Before was able to lock the entrance door before he was able to get back inside of the building. They indicated he was aggressive and continued to behave aggressively, caused alarm to the other people and staff members who were present. And multiple witnesses indicated they were fearful for their safety as he was swinging the knife throughout the location in their presence. And when women and children were present during the incident, appeared to be frightened by his actions. So that was the information that was probably relayed to I have not watched the video, to know what ASG Dudley, other information that he gave them, nor do I know what he asked for as a bond recommendation in the case.
Here's what I believe happened, and I have spoken to Mr. Lope several times, and I've spoken with his wife. The people saw this man. He's a black man with a foreign accent. They probably didn't understand him. Okay, and he may have been making he's not a violent person. He works at the airport. Okay, he's cleared to work. He has a job working at the airport. He is a family person. He is married. He's not a danger to anyone. I am still trying to process why this man is sitting in jail. And the only charge is disorderly conduct. If he was doing all of this and threatening, he didn't threaten anyone or anything like that. I think this is some kind of police officer overreach or something that he's even arrested. But he has only been charged with disorderly conduct. So his bond in this case is not a reasonable bond. And quite frankly, I believe he qualifies for a signature bond. Look at his age. Look at the fact that he has no history other than a nonviolent arrest for marijuana possession.
Pre-trial.
Your Honor.
All right, does anyone have his history? Are you able to?
I do.
Okay, thank you. Tell me what it is.
Oh, for Mr. Lofi, he doesn't have any
Yeah.
history outside of these two charges on the calendar.
He does not have a history, right? Is that what you said?
No other
Okay.
arrests outside of these two.
Okay. All right, Ms. Evans Battle, anything else? You're muted.
Yes, I do see that marijuana charge and the tampering with evidence charge that he has on his prior history. The state's position is that this is a felony. Certainly, while Ms. McLeod asserts that, he works at the airport and he's not a dangerous or violent man, there's still no explanation by that same argument for him to be in possession of a knife, waving it around inside of a public building where there are other people, and certainly not waving or threatening, according to the witnesses, an individual inside of the restaurant. So, I think that the bond is set. It's fair and reasonable for an aggravated assault offense, which is what we intend to charge in this particular case, and that it remains set as is. And I would really, caution if he's, if the plan is for him to get out and then to go to leave the country, then any other bond that the court may decide to reduce it to, we would ask that he not be permitted to leave the country and would have to turn in his passport. Thank you.
Mhm.
Well, he is an American citizen because that is something I determined. It seems like this man is the police officers on the scene, they chose only to charge him with disorderly conduct. We have not seen the videos. I have filed a motion for discovery. We haven't seen the videos. Nobody is trying to suggest what my client tells me that he was there giving away some clothing and other stuff, and this is something that he does regularly. We just don't understand what happened. He denies that he had any knife waving or threatening anybody. That he completely denies. He has no violent history. So
I
had
know
the
he
police
has,
officers, first
Ms.
of all,
McLeod, you're telling me the same thing over and over, and I get it. I do understand. I did not hear the initial case, I don't believe, for the bond hearing. And I think you said it was Judge Law. And, I've not seen the video. I don't have enough information before me at the moment to decrease his bond or to let him out on a signature bond. It is I know that you said it is just a disorderly conduct, but from the facts that
That's
I'm gleaning
correct.
about waving a knife and threatening people, I don't know if that is shown on the video and it was clear. I really don't know. And so I'm hesitant to throw all of that out and say he gets out on a signature bond without much more information. And I know that you're arguing that he didn't do this and didn't do that, and he was only there to pass out clothes. I don't know if he passes out clothes inside a Burger King. Seems like he would have been outside a Burger King. And that's just my,
He was outside, Your Honor. He was outside.
okay. So all these other witnesses, I don't know, and people around, just sounds a little incredible to me. I do think that the bond sounds high, but I don't know, didn't hear all of the facts or allegations that are going on in order to, reduce a bond. Certainly not going to do that in order to allow him to leave the country and go to Senegal. We may not ever see him again. I'm sympathetic about his mother passing and him needing to go there for her funeral or to tend to that matter, but that generally would not be acceptable while on bond. I don't believe either. So I'm
I mean, he's sure.
go ahead. I'm at a loss on what to do.
Yeah, he is charged with one of the lowest possible misdemeanors. He's charged with disorderly conduct. He is not charged with terroristic threats. He's not charged with battery. He's not charged with assault or any of those things. He is charged with disorderly conduct. He had some police officer interaction. His first language is Wolof, and his first two languages Wolof and French. I think there may have been some miscommunication here. Mr. Lopez is not a violent person, and he completely denies that he was waving any knives,
And those
making
are
any
factual.
threats against anyone. And I do not believe that any videos that the state comes up with, I'm predicting this, are going to show any of that. And there is a reason why the charge is only disorderly conduct. I guess the officers had to come up with something. So they came up with disorderly conduct with 25,000.
Judge, I would only advise that on June 6th, when we argued the bond initially, that Mr. Dudley's position was that they were going to seek to transfer it immediately to the DA. And I'm a little surprised at why here we are on the 18th and it hasn't been transferred. And at that point, I think that a reasonable bond should be appropriate. I mean, they've had 12 days to roll this case over and they haven't.
Mm-hmm. Yeah. Check one other thing. Hold on one. All right, Ms. McLeod,
Yes, Your Honor, I'm here.
Ms. State, all right, and the case has not been transferred or reaccused or anything like that, is that correct?
That's correct.
All right, so what I'm going to do, and I see there was an offer on position 35, but not on 36, it says we'll update. So does he already have a bond on position 35?
Yes, Your Honor, he has a signature bond.
He has a signature bond on 38,
In the first
35.
case on the marijuana,
How much was that?
I do not, I would have to take a look, Your Honor. I can take a look to see how much, unless he remembers. Mr. Lope, do you remember how much it is?
There was 250 or 500 or something like that.
Like 2,500, I think, but I'll take a look.
Yeah, no, I think there was 250. Thank you.
Judge, I believe it's actually, it's a signature bond for 1,500. Total is 500 on the marijuana charge and 1,000 on the tampering with evidence charge.
And that was just SOB through the jail. Is that right?
Yes, Your Honor.
All right, and then on.
Yes, Your Honor.
Okay,
Yes,
so
sir.
that bond will remain on position 35, which is 1,500. Signature bond, I guess, through the jail. I don't hear any other,
I think
things
it's
on
for
that.
pre-trial.
Or is it pretrial?
Was it pretrial? I don't remember. I thought it was for jail, but it could have been pretrial. I do not remember.
Well, it
Mr.
just.
Jordan, do you have it or see it? I can't stand when I don't get the right information. I don't
Right.
like guessing. I would like to be factual. What is the bond that's existing now on position 35?
The $1,500, sign-on bond through the jail unit.
Thank you. Okay. All right. So position 36, which is the 26 CR 003626Y on the disorderly conduct. I'm going to keep the amount at the 25,000, but turn it into a signature bond through pretrial. I'm gonna put him on a level 2 and allow him to call in. And no drugs, alcohol, weapons, or guns while on bond. He is to stay away from the Burger King on Old National. Since he cannot have any weapons or knives, if he has any, he needs to surrender them to the sheriff's department immediately.
Judge, I'm not complicated, but I do understand it. He is in airport security and he may have a firearm. I'm not sure. That may need to be at least thought about.
Can we ask him? Mr. Lope,
Yes.
do you have a firearm that you carry for your job at the airport?
I don't have to have it right now. I don't have to have no fire. It just, I lost my mom. It just priority on it. I know I'm not supposed to talk, but I'm not a violent. I'm not a violent people.
No, I just asked you a question. Do you work in security at the
Yeah, I
airport?
was in security at Unified Security. We screen the people at the new race. The people come for them.
So you're in screening, but you don't have to carry
No, we
a
don't have to
gun.
have it inside. Inside.
Okay. All right. So, $25,000 signature bond through pretrial level 2, and I'll allow call-ins and the normal conditions of no guns or firearms. You know, I hate to say unless he needs it for work, but I don't, if he says he doesn't need it for work, then I'm not going to let up off of that requirement right now. And so that's all I'm going to rule on that case for today.
Thank you, Your
Anything
Honor.
else, Ms. McLeod?
No, Your Honor, I haven't
Or the
spoken to my
state?
other client yet, but I will come back on screen when I do.
All right,
Mo-
anything else, Ms. Evans Battle?
My only concern is the leaving the country at this time.
Well, I don't know that I'm going to address that. He has to report into pretrial. And if not, then they'll surrender that bond and it'll be what, 50,000? Because doesn't it double when they surrender? Is that correct, pretrial?
Not that,
That's your honor. That's correct.
All right.
I can appreciate their concerns, but Mr. Lope did serve honorably in the United States Navy for 4 years. He's a citizen. He certainly has got enough ties to the community. If he does go abroad, he's coming back. He's got his life is here. It's not over there.
Right, I understand.
And-
All right, that's why I'm not gonna address that. Because
Thank
he
you,
still
Judge.
has to report in.
And Ms. McLeod, given that the judge has made this a decision, I'm going to jump off the case now. I had not filed an EOA because initially I thought this was going to the DA's office, but I'm going to just file my paperwork. And Ms. McLeod, you can take the second case. Thank you, Judge. Thank you, Ms. McLeod.
All right, thank you. Appreciate you.
Thank you, Mr. Murphy.
Judge,
Thank
that's
you,
all
Your
I-
Honor.
All right, thank you. Yes, you're free to go. Thank you.
Your Honor, can we finish up position 24, Kiana Harris?
All right.
Yes, I need to speak to Ms. Harris because there is an offer and I wish to discuss it with her. If you
Okay.
would call me, please, Officer Milton.
Will do.
Okay. All right, who else can we take, deputies?
Your Honor, Public Defender Alex Chataya here. Brief announcement, position 3 and 4, that's going to be waiver of arraignment, not guilty.
3, 4.
Yes, and I believe position 4 is a duplicate of position 3, according to the
Okay.
calendar.
Waiver. All right, well, we have that.
Yeah, number 15 and 16, Mr. Dawkins next.
Is this still going to be a plea?
It is, Judge.
All right, this is 26 CR 003589E. Jeffrey Dawkins, charged with 1 count of theft by shoplifting. And 16 is 26 CR 003590E. And he's charged with 1 count of theft by shoplifting and a willful obstruction. State.
yes, Your Honor. As to the theft by shoplifting, 12 months, served 30 days, credit for time served, balance probated, complete the theft prevention class, a fine in the amount of $300, stay away from Walmart located at 6149 Old National Highway in South Fulton. As to count 2, 12 months probation, consecutive to count 1, a fine in the amount of $300, stipulate to identity, venue, and a factual basis for the plea. Thank you.
Your Honor, we do stipulate for the purposes of the plea. We would ask to convert his fines to community service. I believe the total would be that would make 110 hours of community service, Judge. Ask to waive 1 month of probation fees and allows probation to terminate or go non-reporting once he completes all of his requirements.
I'm not opposed to non-reporting.
Okay. All right, that'll be 110 hours of community service. All right, Mr. Dawkins, I understand you wish to plead guilty. Is that correct? Okay, you have to speak up loudly so we can hear you, okay?
Okay, yes, ma'am.
All right, raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down and ask you a series of questions to make sure you understand your plea. The first is, are you under the influence of any unprescribed medication, drugs, or alcohol at this time that would impair your understanding?
Not at all.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, it could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes, ma'am.
All right, as to the charge of theft by shoplifting, how do you plead?
Guilty.
And as to the second charge of theft by shoplifting, how do you plead?
Guilty.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, and I will accept your guilty plea and understand your conditions, correct?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor. I
All
have
right.
two other announcements briefly. Positions 1 and 2, we did not, it's going to be reset 625.
Okay,
And that's the same announcement for position 19. There was no offer from the state, so we're going to reset it to next week. And Judge, that concludes my business for the day. May I be excused?
yes, enjoy your long weekend.
Thank
I'm
Okay.
sorry, which cases were those again?
1 and
1
2,
and
19.
19.
Okay, so I sent out an updated calendar for 1 and 2. There is an offer on the calendar, and then
Right, it's position 19 that there still wasn't.
oh, okay. All right then.
Thank you, Judge.
All right, thank you.
Position 51, Mr. Sharp.
And Your Honor, a brief announcement for position 37, Miss Massey. I believe that's going to be a reset to the next SAP calendar. She was taken to a different court for another hearing unrelated to this.
Okay. All right, we'll reset it to next week. Thank you. All right, this is position 51, 26 CR 003658F. Dexter Sharp, charged with 1 count of theft by shoplifting and criminal trespass. Is it still going to be a plea?
This is, Your Honor.
Okay. State.
Yes, Your Honor. It is S count 1, 12 months, serve 30 days, $500 fine, stay away from Walmart at 6149 Old National Highway, and the Walmart at 7050 Georgia 85 Riverdale. We would ask that he complete an anti-theft course. As to count 2 is 12 months probation. Well, it's credit for time served. We just do time served on that criminal trespass case. Stipulate to identity, venue, and a factual basis for the plea.
We do so stipulate for the purposes of the plea, Your Honor. We're simply asking that the $500 fine be allowed to be converted to 50 hours community service.
All right. All right. Anything else? That's it?
Yes, Your Honor.
All right, Mr. Sharp? Mr. Sharp?
Ma'am.
Oh, there you go. I'm sorry. I understand that you wish to plead guilty. Is that correct?
Yes, ma'am.
All right, raising your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. I'm going to ask you a series of questions. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder your understanding today?
Ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're on probation, it could be affected by your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So as to the charge of theft by shoplifting, how do you plead?
Guilty, ma'am.
And as to the charge of criminal trespass, how do you plead?
Guilty, ma'am.
All right. I'll accept your guilty plea and you understand your conditions and community service, correct?
Yes, ma'am.
All right. Good luck to you.
Thank you, Your Honor.
All right. Thank you.
Counsel, would you please state your name for me?
Zachary Judd with the Public Defender's Office.
Thank you.
Yes, ma'am.
All right, next we got number 50, Mr. Parks, no, not Rhymes.
And this is which position? I'm sorry.
50.
50. Okay. This is 26 CR 002936A. Tony Rhymes charged with 1 count of simple battery and a 2nd count of simple assault. Is there an offer from the state?
No, I don't believe so, Your Honor. I've actually filed a motion to modify bond, Your Honor, for Mr. Rhymes. I'm in Judge Roth's courtroom. That's where this case is. Judge Roth has requested that for the time being, for the sake of the clients and their motions being heard sooner rather than later, that we put all bond modifications for clients in custody on the SAP calendar. So that is what we're here to do today, Your Honor. I filed a bond modification in this case, and I would like it to be heard today.
All right.
Your Honor, OCGA 17-6-1 states that once a person is authorized to be released on bail, when determining the bail amount, the court shall consider financial resources and other assets, the accused financial circumstances, earnings and other income, financial obligations and obligations to dependents, the purpose of bail, and any other factors deemed appropriate by the court. So in regards to his financial assets and abilities, Mr. Rhymes, he doesn't own any property. He has very low financial ability. In regards to his financial obligations, he's currently living with his sister. They do share the responsibility of the financial obligations of the home, which the sister cannot hold all by herself, which he has had to do since Mr. Rhymes has been in custody, which I believe has been a little bit over a month now. He does take care of his 4 granddaughters aged 13, 11, 10, and 4. His mother also lives in the house with him and his sister, and he actually received the news about a week ago from his sister that the mother just had a stroke. She is bedridden, and he is also responsible for those medical bills as well. Your Honor, Ayala v. State found that the purpose of the pretrial bond is to prevent punishment prior to conviction and to secure that the accused appears for court. Mr. Rhymes is being held on another felony charge right now. So I do understand that if the judge does grant this modification, that Mr. Rhymes will still be held. Our hopes is that once he does resolve his other case, he can be released and later address this case. Your Honor, just to be candid, I did see that Mr. Rhymes does have an FTA, so he may not be eligible for a signature bond, but we are asking for a very minimal cash bond. Right now, he Right now, his bond is $1,000 per charge. We're asking for a $50 cash bond to be set on each charge, Your Honor. He is unable to afford the bond as it stands. I only represent him in this misdemeanor case, so I can only speak for this case. But right now, for this case, the bond as it sets is currently acting as basically a detention order, a no bond, if you will. So for those foregoing reasons, Your Honor, we are asking for that bond modification.
All right, State.
Yes, Judge. For the court to consider a bond reduction, well, I know you've indicated that there was a motion that was filed. We don't have a motion before the court other than the motion in limine, I suppose, oral motion that she's making right now.
She said, hold on a second. I thought you said you had filed the motion to modify.
Yes.
Can you email that to us? If the state doesn't have it, they need to have a copy.
Brief
Did you
indulgence.
e-file it?
Yes, Your Honor, brief indulgence. I can let you know the exact date.
It's filed on the case, Judge. I'll email it to you.
Okay. Can you email Miss Evans Battle as well?
Yes, so I apologize.
That was Mr. Jordan talking. I was speaking to Mr. Jordan. I'm sorry. PD Ulysses.
Yes, so I did file the motion May 28th. I shared it with the solicitor in my courtroom because technically this case is in Judge Roth's division, so I do apologize, ASG Evans Battle. So I didn't directly share it with you. But if you want, I can go ahead and email that to you, but it is filed as of May 28th of this year.
Okay, and I just need a copy of it so that I can put it in the file as well. But as this case happened, the incident happened back in October 4th of 2025 at 2356 Herring Road. Dolores King is the victim, who indicated that she was pushed to the ground by Mr. Rhymes, who is her ex-boyfriend. He came to her workplace causing a disturbance because she would not walk with him. He brandished a handgun, stating that she would end up in Grady while waving it around in the air. I know the pretrialist here can give a better history than I can. I have 26 cycles of significant violent arrests, prior weapons arrest, a 2024 FTA, and there were some violation of probations. He does have a felony aggravated assault case that is open as well. The court, this case appears to have had a signature bond that was previously set on this case is what, I'm sorry, it's a lowest surety bond because of the FTA. The lowest surety was given, it was $1,000 as to each count. So he doesn't qualify for a signature bond. We were not asking for a cash bond, we just were asking for the lowest bond that we felt were available, which is $1,000 on each count. And the court can hear, from pretrial as to history, I suppose.
Pretrial, I don't know that you have much else other than what the state has given, do you?
Well, no, she said the open case also is battery, family violence, first defense. I know she said the ag assault part, and then there were 6 other convictions outside of the 10-year period. She said the 2024 FTA, and there's also an 04 FTA. Other than that, there's nothing further.
All right, thank you. All right. If there's nothing else, I'll go ahead and rule that we're going to leave the bond as set at the $2,000 surety, 1,000 for each. I'm going to deny the request to convert it to a cash bond or decrease it in any other manner due to obviously his history, convictions, and just don't think it warrants a reduction at this time. I sort of agree with the state. It's not a very high bond. So, and I know he has other cases, open cases, FTAs, and the felonies. So I am not going to modify or reduce the bond at this time.
Okay, thank you, Your Honor.
Thank you.
And Your Honor, I actually have one more bond modification on today's calendar, position 20.
Okay.
If we can address that as well. And I'm sending that the bond modification motion that you just ruled on, as well as position 20 to ASG Evans Battle right now.
Okay.
Okay, I'll just go ahead and make my
Oh,
argument.
let me go ahead and call the case. I'm sorry. 26 CR 002834A, which is Marco Antonio Garcia Enriquez, charged with 1 count of simple battery, family violence. And go ahead, PD.
Yes, Your Honor. Again, as I previously stated, once the bond has been set, the court shall consider the financial resources and other assets and earnings and incomes and financial obligations, the purpose of bail and any other factors the court deems appropriate. For Mr. Enriquez Ruiz, he has no property. He has no college education. His financial abilities is extremely limited. He is, before being detained, he was living with his wife and his children, which he was the sole provider for. He lived with his wife and his 4 children, all under the age of 18. He worked as a landscaper, and on the weekends, he worked at a car wash in order to be able to pay the bills for his family. Right now, Your Honor, his bail has been set at $1,000. He is unable to make that bond amount. I don't believe he has any FTAs on his record, so he is eligible for a signature bond, which is what we are asking for today. Mr. Enriquez has been in custody since May 3rd, making today his 47th day in custody. There has been an offer made in his case, but he would like the opportunity to contest the allegations, Your Honor. He doesn't want to feel forced to plead in order to be released from jail. Additionally, Your Honor, he would have another place to stay if released other than the place of offense. He has an aunt that he can stay with. He doesn't have any felony convictions. He does have a previous arrest for kind of similar charges, but those charges have been dismissed. So we're hoping that the court takes the fact that that previous case has been dismissed into heavy consideration. Also, the client will be complying with any stay away orders or no contact orders that the court imposes. Again, Your Honor, he's been in custody for 47 days today. He wants an opportunity to contest the allegations. So we are asking that the court modify his $1,000 surety bond to a $1,000 signature bond, or a higher, amount signature bond, if that's what the court deems appropriate.
All right, State.
Yes, Your Honor. This case stemmed from a May 3rd of 2026 incident where they were arguing over the fact that the victim was leaving the apartment and him And on this day, the arguing continued while she was cooking, and defendant came from behind her and forcefully wrapped his arms around her neck, saying, "You're not going anywhere." The victim in the case is Maria Enriquez Ruiz. She confirmed the events that happened in the warrant and indicated that they are married or not legally married, and confirmed that they do share 4 children. She indicated she was very scared when the defendant was walking around there because he had a knife. She says that she was okay with the signature bond, but based on his prior case, which was obstruction, willful obstruction of law enforcement officer, simple battery, and cruelty to children. It was a Superior Court case that they actually didn't present for lack of prosecution, I believe it was, on that previous case involving the same victim, is my understanding. The victim's position was at that point in time that she just wanted to ensure that he was not returning to the residence. So we also had asked for a third-party transfer of the children for custodial purposes. That was the lowest possible bond, which is the $1,000. And the state maintains it's a public safety case, and we would still maintain that $1,000 surety is an appropriate bond in this case. Thank you.
Your Honor, if I may.
Mm-hmm. Yeah.
In just regards to the allegations, it does state that, there was no sign of injury on the alleged victim. As well, I believe the state mentioned a knife. It also states that that there was no knife pointed towards her. That he did not threaten her with it or anything like that. And then I also believe the state did say that the alleged victim would be okay with him receiving a signature bond. So yes, again, we would ask for that modification to a signature bond. I believe he is eligible, and the felony case that the state was referring to is the case that, like she stated, was dismissed.
And the criminal history summarized for me.
Yes, Your Honor. He has 3 cycles, and then there's a 2023 conviction from Roswell for driving without valid license. Nothing further.
And he's been in how many days, PD list?
47, Your Honor.
All right, I will modify the bond and have the bond be modified to a $3,000 signature bond through pretrial. With that signature bond through pretrial, he will be at a level 2. And he is to take 5 anger awareness courses through pretrial. He is to have no further contact with the victim, Maria Enriquez Ruiz. He is to stay away from her residence, her job. He's to be 200 yards away from her, or 2 football fields away from her. He is to not contact her by phone or email, no social media contact with her. And I think there's already a third party transfer person, which is the victim's uncle, Cristobal Enriquez, if visitation is allowed. with the child. But there's a stay away and no further contact, still with the victim. Anything else that I leave out? State,
No, Your
any
Honor.
other conditions? Oh, no drugs, alcohol, weapons, or guns while on bond. All right, that's the order of the court.
All right, thank you, Your Honor. And that actually
Oh.
concludes my business. May I be excused?
Yes, you may. Thank you.
All right, thank you.
Your Honor, can we finish up position 24, Kiana Harris for Attorney McLeod?
Yes. All right. What are we going to do, Attorney McLeod?
Now, this is going to be a negotiated plea.
All right. This is 24, which is 26 CR 003464J, Kiana Harris with 2 counts of simple battery, 1 count of battery family violence, 1 count of cruelty to children in the 3rd degree. Okay.
All right, as to count 1, 12 months, served 60 days, credit for time served, balance probated, complete the FVIP, also complete an MHET and ADET as well. No further violent contact with son Tiana Bailey. A fine in the amount of $300 and 40 hours of community service. As to count 2 is be 12 months probation, no further violent contact with Santiana Bailey to run concurrent with count 1. As to count 3, it would be 12 months probation, complete your family violence intervention program, no further violent contact with TA, a child, and that would be running consecutive with count 1. As to count 4, it's 12 months probation, concurrent with count 3. So that would be no further violent contact with Quavadius, Quovadis Harris, restitution in the amount of $500. And as to the last count, it would be a 12 months probation to run concurrent. So that's a 24-month supervision case. We are asking that she stipulate to identity, venue, and a factual basis for the plea.
We do so stipulate.
All right. And Ms. Harris, I understand that you wish to plead guilty. Is that correct?
Yes, speak up.
I can't hear you. You got to speak loud.
Yes,
All right. Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes,
All right. Put your hand down and speak loud and clear so the court reporter and the recording can hear you, okay? All right. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that would hinder you from understanding today?
yes,
I'm sorry?
yes,
Let me ask you that again. Are you presently under the influence of any unprescribed medication, drugs, or alcohol? At this time, are you under the influence of any of that that would hinder you from understanding today?
speak up. No,
Do you understand my question?
yes,
Okay, so you've not consumed any alcohol or unprescribed drugs or any unprescribed medication or drugs today, is that correct? Can you hear me?
what did you say?
Do you understand the questions that I'm asking you?
Yes,
Have you had any unprescribed medication, drugs, or alcohol today that would not allow you to understand these proceedings?
no,
All right. Are you satisfied with the services of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
And you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to a trial by judge or jury, whichever you prefer?
Yes.
And you are prepared and agree to waive these rights today, is that correct?
Yes.
Has anyone promised you anything to plead guilty today?
No.
Has anyone told you you would get a lesser sentence for pleading guilty?
No.
You understand that if you're on probation, it could be affected by your guilty plea today?
Yes.
Do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes.
All right. And so as to the charge of battery family violence, how do you plead today?
Guilty.
I'm sorry?
Guilty.
Okay. As to the two charges of simple battery, how do you plead?
Guilty.
And as to the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of cruelty to children in the third degree, how do you plead?
Guilty.
All right, I will accept your guilty plea. And you've got a lot of conditions to complete there. You understand those that you discussed with your attorney?
Yes.
Okay. All right, if you have any other questions,
Your Honor,
without call your attorney. Yes.
yes, Your Honor, I would ask, given the fact that she's been locked up for quite some time and she is not currently employed, if the court would consider waiving at least the first 3 months of probation fees to allow her to get back out and get back on her feet.
I can waive 1 month of the fees.
Thank you, Your Honor.
All right, thank you.
All right, if you have 25 and 26, Hernandez Dominguez.
Huh? This is 26 CR 001043J. Nestor Hernandez Dominguez charged with 1 count of criminal trespass, 1 count of loiter and prowling. And the second case is the 26 FTA ending in 1023. Okay.
Your Honor, this is my case,
Oh, I'm sorry.
and I was hoping to get this case, to get his bond reinstated, Your Honor, because from some oversight, and this is completely on my part, because I represented him at his first appearance, and when I went back to check, for some reason, I had filed I had prepared all the appropriate pleadings in his case, including a waiver of arraignment and so on. And they were just sitting in his file and they were unfiled, and I did not realize it. So he missed his arraignment. Since then, I have filed a waiver of arraignment on his behalf. And the reason why I'm asking for all of this, Your Honor, is that I remember this case distinctly. My client had just been standing at a gas station with a young lady, and it was a very, very busy gas station in the middle of the day, and yet the state ended up charging him with loitering and prowling, even though I believe the warrant had said it was like 10:30 in the morning, and he was just standing up there with this young lady, and he had told me he was just waiting in a labor-ready situation, trying to look for work. So that was the basis of his charges, criminal trespass. They were saying that he was just hanging out. This is a very, very busy gas station, Your Honor. It was in the morning, like 10:30. I remember this very distinctly because Judge Lal was the one who who presided at at his initial bond hearing, and she specifically mentioned that she knew the location and it was an extremely busy area. So at the time, we felt that the charge of loitering and prowling was really not a good charge, since it was 10:30 in the morning at a very, very busy gas station. And also, he had said he had just been there waiting for work. So this is his first time missing anything, Your Honor, and I'm asking if we could get his bond reinstated, because I do not believe, based on what I know about the case, that the plea offer is reasonable.
And you're saying to get his bond reinstated?
Yes, Your Honor. He was out on bond. It's not like he's had a new charge. It's the FTA while he's in jail.
Judge, I think she is confusing the facts of this case perhaps with another case. In this particular case, the incident happened on February the 15th of 2026, and it was at between the hours of 12 a.m. and 12:17 a.m. And this was at the Exxon gas station. He was actually in a back corner wall of the business, and had been previously served with in Roswell with a criminal trespass warning to stay away from this particular business. The officer indicated that they were doing a check on the business at 1105 Holcomb Bridge Road in Roswell, and came in contact with individuals, could smell an odor of burnt marijuana coming from the area where the subjects were standing, and that the business, it was unusual time for the business because of the hours of the day. The individual identified as Nestor Hernandez Dominguez, and another female identified as Norma Shaw had previously been served with notice not to be on the property. They search of the Miss Nestor, there was a smoking device that was used and commonly known. Both were confirmed in the system as having been given warnings previously, so they were arrested. So that is the facts of the case, and he was on the and I didn't know if he needed there's a note in here about a Spanish interpreter as well, I see in this case. I don't know what happened there.
He does need an interpreter.
He does?
Yes.
We've just had a
when I spoke with him the last time, there was an interpreter.
Oh boy, I wish you would have told us that at first. We would have gotten her on the line before we started doing all this, because he's not going to be able to communicate, I guess. I don't know.
So he's
Do we
not
have an
understood a word that
interpreter?
we've said.
Huh? Ms. Champion or Mr. Jordan, do we have an interpreter available? And is he trying to take a plea, Miss McLeod?
Your Honor, I
Or you
haven't
just
been able to speak to him about the plea offer, but just in preparing the case, when I realized he was on the calendar, and I went to check because what did he miss? And then I realized what had happened. But I have not been able to speak to him about the plea.
Ms. Champion?
Yes, Your Honor, we can reach out to and see if we can get an interpreter on the phone.
Okay, if we can. If not, we'll just have to reset it.
Yes, ma'am.
All right, we'll hold for a second, see if we can get one of them on the line.
Move to another case while I try to get an interpreter, y'all.
Okay, thank you.
I got position 22 and 23 at ACDC, Ms. Harnett.
And where are we with the private attorney, Mr. Korn, with Marcus Van?
Your Honor, I'm here for that.
Oh, or is that the
Yes, we've accused the case.
Oh. Really? Judge, may I be heard on bond?
he's on, is he on this calendar or he's the add-on?
He is an
He's
add-on
an
that
add-on.
case, and I thought maybe we were waiting till the end of the calendar. I'm not sure.
I don't,
I received a message this morning asking if this case could be added um to the calendar, and of course, our practice is to accuse the case for a bond hearing, and so that's what we've done at this time.
has that been added, Ms. Champion? 'Cause I don't have it.
I think Mr. Jordan was working on it.
Ms. Champion, is Mr. Jordan working on that or not?
Yes, Your Honor, we're currently working on it at this time.
Okay. All right, hold for a second. Attorney Corn will get with you as soon as we can. Oh, there goes Mr.
Thank you very
Jordan.
much.
Yes.
I'm back. Sorry, I had walked out the office. Is this for Van?
Yes.
Yes.
Okay, so the case was filed this morning, and then we did initiate it. The case number is 26 CR 004-007 L. Let me see. Are you gonna do the bond here?
Uh-huh.
Okay, so the case number is 26 CR 004-007 L. State of Georgia versus Marcus Van. Is one count of battery family violence, and the second count is simple battery family violence. I'm not sure about the incident dates, but the battery family violence has an incident date of 4/5/2025. And then the simple battery family violence has an incident date of 06/03/2026.
Okay.
That is correct, but not
Okay.
exactly sure how they're going to be in one accusation, but we can worry about that later. For now, I just want to deal with the bond.
Okay. And we haven't gotten to the add-on calendar yet, but I do try to, if I can, be a little appreciative of private counsel's time where I
And I
can.
appreciate that.
Who's sitting in the chair in courtroom 2?
That's not Mr. Van.
That's not him. Okay.
No,
I may have to take this one, huh?
Van is in courtroom 1.
Oh,
Yeah, that's him there.
oh, in courtroom 1. Okay. Can I do that one first, or do I need to do courtroom 2 first?
Judge, you can take care of the power of attorney matter first.
Okay. All right. Let's do the add-on with Mr. Van in courtroom 1.
Would you like me to go ahead, Your Honor?
I'll call it real quick, 26 CR 004-007 L. And this is a bond hearing, so I will let the state go first, and then you can present.
Thank you, Your Honor.
Let's give them a second. We're going a little bit out of order, but
Hold on a moment.
Okay, sorry about that.
Yes, I'm looking at the warrant. It appeared that there were two incidences on the battery case. Okay. The battery case, it appears, happened in April of 2025, in which she reported the victim in the case is Arija, Arija Van. She reported that she was assaulted by her husband at 2125 Southwood Cove, Southwest Atlanta. The report was just taken on the 5th, based on the report of the other incident. So it appears back in that time, she indicated that that there have been several instances of abuse by the defendant since 2024, and that she's caught him with escorts, and he was taking their daughter around inappropriate people, that she confronted him and he became irate. As to the 425 incident, he caused visible injury to her by striking her in the mouth and violently grabbing her arms repeatedly, resulting in a busted lip and scratches all over her arms on that particular incident. The next incident is the June the 3rd warrant, and the allegation that occurred that date at the 2125 Southwood Boulevard, Southwest address, and that he, at that point, she was confronting him about inappropriate behavior, and that he became outraged. He pushed her, he walked past her, and when she confronted him about it and pushed her, his arm around her arm out, putting his arm out, knocking her into and pushing her back into a closet. The anger escalated, and she just said that she decided she was done and didn't want to engage anymore. As she walked past him in the kitchen, he violently grabbed her, spinning her wrist, spinning her around and stopping her from walking past, and pushed her back and to a raised countertop and proceeded to stand in front of her, preventing her from moving. Once she did not engage anymore, the situation lost steam, and she reported it. There appears to have, she did tell the officers that there was a prior arrest out of DeKalb County, which eventually she decided not to pursue prosecution in that particular case. I know that our victim advocate spoke with the victim, and she was supposed to have been on the Zoom this morning. I'm not sure that she is, but our bond recommendation in this particular case would be for a $3,500 surety on the battery family violence case and a $2,500 on the simple battery family violence case, which would make for a $6,000 surety bond, that he have no further contact with the victim, and that he stay away from the 2125 Southwood Boulevard Southwest location. He can get a one-time police escorted visit to retrieve any property there. We'd ask for a third-party transfer or any children in which they share as well. and no alcohol, drugs, or weapons or firearms while out on bond. I know that the court, they will probably be asking to consider his job may require him to carry a firearm, but our position at this time is that he have no firearms and that any that he has or possess should be surrendered to the sheriff's department. Thank you.
All right, Attorney Corn.
Your Honor, Mr. Van is 40 years old. He has no criminal convictions of any sort ever. He has graduated from high school. He has some college. He has spent his entire lifetime in the state of Georgia. He has very steady work for the city of Forest Park, which does require him to carry a firearm. So we would ask that he be permitted to keep his firearm while in the course of his duties. He does have one child with the victim. He would not live there. He has his entire family lives here. His sister Kendra indicated to me that he could live with her. Plus, I'm sure there's a variety of other places he could live that aren't that house. When he learned of this warrant, which was issued yesterday, he immediately came this morning to the Fulton County Jail and he turned himself in. That's because he wishes to see this case through. He is not a flight risk. He is not any danger to anybody. We would ask that he, with that in mind, we would ask that he receive a signature bond. The amounts that the state recommended is fine as far as that goes, but we would prefer that it be through a signature bond.
All right, and I did skip over one thing that we normally do, and that is pretrial. I don't know if you had a chance to pull his history or not. You did?
I did, Your Honor.
Okay.
He just has one prior arrest from DeKalb. It was for battery, family violence, but it was dismissed.
Okay. Thank you.
Judge, if you will sound for the victim, I'm not sure. I don't really see anyone that's on here, but just in case I'm missing something.
And I don't recall her name, if you could sound or tell me that.
Miss Van is Arija, Arija Van.
All right. Arija Van, or Arisha Van. All right, she's not on. I am a little concerned, although the one prior case was dismissed, it is with the same victim, correct?
Yes, Your Honor.
It is, Your Honor.
Okay. And so I don't want this victim to be fearful or to feel afraid. I would prefer that he go on to a surety bond. And that one prior that was dismissed, wasn't it last year? What year was it?
It was a few years ago, I believe.
Was it a few years ago?
It was
I wanna say-
2018.
20 what?
Yeah.
18.
Oh, 2018. Okay.
Yeah, September of 2018.
All right. I apologize, counsel. I thought it was more recent, but
So did I.
still the allegations sort of bother me. And I know they are allegations.
Right. Which he does deny.
Okay. I think what I'll do is give him a $6,000 signature bond through pretrial. And with that 6,000, it would be 3,500 on the first charge and 2,500 on the second charge. For that $6,000 through pretrial, and I'll put him on level 1. he is to, the second case happened on June 3rd. But since he does have somewhere else to go live, to make sure that things have cooled down, I will order that he stay away from the incident location or the marital home. I'm going to order that he have, and we've not heard from the victim. Is that correct, Ms. Evans Battle?
No, not to state one way or another regarding contact.
Right.
She was notified of the hearing today.
Okay. And usually to err on the side of caution, Attorney Corn, I will order no further contact right now. If you need to request a modification later, you can do that. But I'm going to order no further contact and a stay away right now.
Of course,
If,
Your Honor.
yes, if there are any children, they should be, and visitation is allowed, then that should be facilitated by a third party so as not to violate the bond conditions. I don't know if he needs a one-time escort back to the property to get any personal belongings. I don't know if you're aware of that or not, Attorney Corn.
I believe that he probably does, but I'm not 100% certain on that.
Okay, well, I will order that a one-time law enforcement escort back to the property to retrieve any personal belongings. I'm going to order that he take 5 anger awareness courses through pretrial. And those are free through pretrial. I'm also going to order no drugs, alcohol, weapons, or guns while on bond. And I do sympathize and understand that he has to carry a weapon for his job because there are 2 incident dates, April, June. Then there was a prior that was dismissed, although it's very remote. I am a little concerned about him carrying a gun for work. I don't know what his, I guess, his area, or what type of work does he do for Forest Park?
He's in law enforcement, Your Honor.
Mm.
Yeah.
Ouch. I didn't realize he was an officer.
He is.
State what I generally sometimes would recommend is desk duty, but you know, he obviously, and he may have other firearms that were in the home that need to be surrendered or that he has on a personal level. I would say if they're personal firearms, those need to be surrendered. He shouldn't have any personal firearms. I'm just not comfortable because there's a little history here. That we allow that. What's the state's recommended that he not have any firearms even for work?
Your Honor, that was my recommendation.
And it's our belief that as long as he's in Forest Park on the job, he wouldn't have any contact with her. He wouldn't be anywhere near her. He should be able to have his firearm so that he could do the job he was trained for and hired for.
Well, that's the problem. I know Forest Park and I'm just not comfortable with it at all. So I'm going to order that he not have any firearms, and maybe you can broach this again with a modification, but I'm not comfortable with there being 2 different incident dates last year and this year, April the 5th of 2025 and then June 3rd of 2026. Is that correct, State?
Yes, Your Honor.
I'm just not comfortable with it. And until we know that this is cooled down and he's completed his courses and conditions, he can't carry a firearm right now. I'm going to put that in the order, and it can be modified and reviewed later. But right now, if he has personal firearms, I would like them to be turned over to the sheriff's department within 24 hours after his release. And then no firearm at work. Hopefully they can find something else for him to do that does not require him to have it, or desk duty for a moment until we get beyond and understand what's going on here. We also need time to speak to the victim and make sure that she's going to be safe, and have that moment to do that, because she was not apprised of this bond hearing today. So we need to speak with the victim, or the state does, with their victim witness assistant, to find out what will make her feel safe, or what her thoughts are about it. All right.
Thank you, Your Honor.
Anything else that
No,
I need
Your
to
Honor.
address? Okay. All right. Thank
Nothing
you.
from the defense. Thank you,
All right.
Your Honor.
Thank you. Mhm.
Next, Your Honor, is position 22 and 23, Hardnet.
Your Honor, this is my case. It's going to be a negotiated plea.
Thank you. This is 26 CR 0000106B Chanel Hardnet, charge of 1 count of theft by shoplifting. And 23 is the FTA ending in 103L. State?
Yes, Your Honor. 12 months to serve, 30 days credit for time served, balance probated, a fine in the amount of $500, 40 hours of community service, stay away from Walmart, located at 844 Cleveland Avenue Southwest, East Point. And to complete the anti-theft course, stipulate to identity, venue, and a factual basis for the plea. The state would move to null pros the FTA at this time as well. Thank you.
And
Okay.
the defense stipulates, Your Honor. We also ask that the first 3 months of probation fees be waived and probation to go non-reporting once she completes the requirements. It is a law for her. She's still in custody waiting to be heard on a probation violation, which will be heard on August 21st in Superior Court. So that's the reason for my request.
I can only waive 1 month of probation fees. And what about non-reporting or anything? What's the state's feeling on that?
Once she completes the conditions, we'll be fine with non-reporting.
Okay. All right, Ms. Hardinet, I understand that you wish to plead guilty. Is that correct?
All right. It's negotiable. Yes.
You'll have to speak up
Yes.
and, okay, and raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
All right.
All right, put your hand down for me. And I'm going to ask you a series of questions to make sure you understand your plea, okay? All right?
Correct.
Okay. Are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
I'm sorry?
Correct.
Okay. Do you understand that by pleading guilty, you are giving up and waiving the right to trial by judge or jury, whichever you prefer?
Correct.
And do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Correct. I just had a question. I paid the oh Jesus.
This is taking a plea. Now, there's something you need to discuss with your attorney, because I'm not here to answer questions about.
This
I'm
is
sorry?
for a different matter, Ms. Hardnett.
Okay, Okay, go ahead. However the process, go ahead.
All right, do you understand that by pleading guilty today, you're giving up and waiving the right to remain silent and not testify against yourself?
Correct.
And are you prepared and agree to waive these rights today?
Correct.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, Lo, I don't know the question. I don't know the question. I can't have an opinion like damn. I don't know what she said.
I'm not asking for your opinion. These are questions. Has anyone promised you?
I couldn't understand the last question that you said.
And I'm going to try to repeat it if you would let me do that. And maybe I can paraphrase a little bit. Has anyone told you that if you pled guilty, that you would get a lesser sentence just to plead guilty?
No, I don't understand, but no.
Has anyone promised you anything to plead guilty?
No.
All right. And do you understand that if you're currently on probation, your probation could be revoked or terminated by a guilty plea today?
Okay.
And you understand that, correct?
Okay. Yes.
Yes. Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
And so as to the charge of theft by shoplifting, I'm sorry. Yes, as to the charge of theft by shoplifting, how do you plead?
Guilty.
All
I
right.
was the FTA.
I'm sorry?
I said the FTA. You said the FTA is the
No, I didn't. No,
okay.
I just said as to the charge of theft by shoplifting, how do you plead? Can you say that so the court reporter can hear you aloud again? How do you plead?
Not guilty. Guilty.
Which one is it?
Not guilty. You confusing
Okay.
me. Guilty.
I'm not, if you would please be quiet and listen to my question, it's pretty simple. Okay? And this is
Every
recorded.
time I
and
answer, they have to say, please don't.
I'm getting ready to not accept your plea just because of your attitude and your conduct in court. My questions are pretty simple. So I'm going to ask you for the last time to make a clear record as to the charge of theft by shoplifting. How do you plead?
Guilty.
And the FTA will be dismissed upon the acceptance of your guilty plea. Was that your other question?
Yes, can I have a question. I already paid the FTA. That's why I was saying why
Did you not hear me? The FTA is being dismissed or no pros upon your guilty plea to the theft by shoplifting. So that FTA is not being charged against you.
But
At
that's
this
what I
time,
was saying.
that you're pleading guilty.
Just leave it alone.
She said I can respond to the question.
Leave it alone, please. Please leave it alone.
I was saying I paid the already.
Okay, let's leave it alone. You're going out. You're leaving. You're going home. Leave it alone. You're going home. Leave it alone. Be quiet.
You've been doing a lot.
Sorry, Your Honor.
All right. And so, Ms. Hardenett, do you still wish to plead guilty to the one count of theft by shoplifting?
Correct.
All right. And do you understand that the FTA is being dismissed according with that goes with this charge of theft by shoplifting? Do you understand that?
Correct.
Okay. All right. And you do have quite a few conditions. The biggest one being to stay away from the Walmart on Cleveland Avenue. Are you aware and fine with those conditions?
Absolutely.
All right. And your attorney explained to you, you have a theft prevention class to take. You have 40 hours of community service. You have a $500 fine. And if you go back to the Walmart, you'll be rearrested. Okay.
Okay.
Okay. I'm making sure you understand your plea. That's my purpose as the judge, to make sure that you understand. Because you can't step out of here and say, I didn't know, and go back to the Walmart tomorrow and you'll just be rearrested again. Okay?
Well, I don't have a say so. Every time I speak, it's a problem. So I
Well,
do
this
understand.
is okay. That's all I need you to say is you
Yeah,
understand this is not a,
I don't even shop at Walmart. I understand, ma'am.
well, you did on January the 4th of 2026 when you were arrested. Correct? Did you get arrested in Walmart?
That still wasn't. I'm saying I'm gonna just take it what it is because that still wasn't the situation, but it's okay. It's okay. No worries.
All right. Thank you very much.
All right, next we got number 44, Mr. Parks.
Okay. This is Donnie Parks, 44. This is 26 CR 0037772C. And Mr. Parks is charged with criminal trespass, simple battery, and terroristic threats and act. State.
Yes, Your Honor. We're asking for, as to count one, it would be 12 months probation, credit for time served. And count two would be 12 months probation, credit for time served, balance probated, complete the Operation 21 Law and Decision-Making course. As to count three, it'd be 12 months probation, credit for time served, balance probated, complete 8 weeks of anger management, also complete an MHET. We're asking that there be no further violent contact with law enforcement. This is actually a law enforcement case that was transferred from Superior Court. And I know that that's not noted in the disposition, but I don't think it's unreasonable under the circumstances that he stipulate to identity, venue, and a factual basis for the plea.
Thank you.
Your Honor, we do so stipulate for the purposes of the plea. We do ask that the first 3 months probation fees be waived.
You can only waive 1 month.
Yes, Your Honor.
All right, Mr. Parks, understand that you wish to plead guilty. Is that correct?
Yes, Your Honor.
Raise your right hand for me as best you can. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions to make sure you understand your plea. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder you from understanding today?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And that you're giving up the right to remain silent and not testify against yourself?
Yes, Your Honor.
And you are prepared and agree to waive these rights today?
That's correct.
And has anyone promised you anything to plead guilty today?
No, ma'am.
Has anyone told you that you'd get a lesser sentence for pleading guilty today?
No, Your Honor.
And do you understand that if you're on probation, your probation could be affected by a guilty plea today?
That's correct.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
And so as to the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of simple battery, how do you plead?
Guilty.
And as to the charge of terroristic threats and acts, how do you plead?
Guilty.
All right, I will accept your guilty plea, and you do understand your conditions, correct?
Correct, Your Honor.
All right. So your plea is accepted, and good luck to you.
Thank you, Your Honor.
All right, thank you.
All right, we're going back to number 12 and 13, Mr. Burton.
Okay. This is 22 CR 0076665E, Andrew Burke, charge of one count of disorderly conduct. And position 13 is the FTA ending in 1029.
Yes, Your Honor, as for the disorderly conduct, it's 12 months or 30 days, credit for time served, balance probated, complete 300, pay a fine in the amount of $300, complete 3 anger management classes, stay away from the incident location at 179 Haygood Avenue, Atlanta. Says no further contact with the victim. I'll have to look that information up. I don't have the person's name right in front of me. And the state would agree for a non-reporting upon completion of the conditions. We would move to null pros the FTA and ask that he stipulate to identity, venue, and a factual basis for the plea.
All right.
Your Honor, we do so stipulate for the purposes of the plea. I just did want to bring up the fact that Mr. Burke does not currently have a paying job. He's in the Gateway program, and there's a possibility that he doesn't have a place to live once he gets out because they're only supposed to miss 3 days. So we are asking that the $300 fine be commuted to 30 hours community service. And if we can get that first month's probation be lifted, we're also asking that it be allowed to terminate upon the completion of the conditions. Your Honor, he did believe that he had handled this case. He had a 2025 criminal trespass case where they brought up this disorderly conduct charge. And so his understanding was that they were doing a global plea on both of them together. He thought that when he pled, he was done. He did not intend to miss court. He just thought he was done with this case. So that's all we're asking for, Your Honor. He's also 1 week away from completing his lift program for forklift certification.
All right. So I think the state said to go non-reporting. Is there any objection to terminating, or is it non-reporting?
Well, I mean, that was what the negotiated plea was for, but I'm not, it's a 2022 case. Just long as he stay away from the victim. I have the victim's name and the location. The victim's name is Thomas. Last name is spelled G-A-N-A-H-L.
Maybe Ganal, maybe. We can terminate if you can agree to stay away from this victim. Otherwise, it would just go non-reporting.
We're fine with that, Your Honor. He
All
will
right.
anyway.
All right, I'll accept that it'll terminate upon completion of the conditions. And so we're going to convert that fine to 30 hours of community service. Okay. And I will waive that 1 month probation fees.
Thank you, Your Honor.
All right, Mr. Burke, I understand that you wish to plead guilty today. Is that correct?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions and make sure you understand the plea, okay?
Yes, ma'am.
First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder you from understanding the plea today?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Very, thank you.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Also, yes, ma'am.
And you are prepared and agree to waive these rights today, correct?
Yes, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, it could be affected by your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right. And as to, and hold on a second, I lost my spot. As to the charge of disorderly conduct, how do you plead?
Guilty, ma'am.
All right. And then the FTA will be dismissed, okay?
Thank you. Thank you.
All right. Good luck to you. All right. You're welcome.
Next, Your Honor, position 28 and 29, Miss Hunt.
And I see we have the Spanish interpreter on, and we're waiting. Is Miss McLeod back?
Yes, Your Honor, I am here.
Okay.
The case there now. He's right here.
Okay. Let me go back to that case so we can get our interpreter. She has to move around a lot. So unfortunately, we need to take that case before 28. So this is, let me go back to position. What is that case again, Ms. McLeod? Just give me the name and then was it
It's petition 25 and 26. Hernandez Dominguez.
right, that's it. All right, Miss Chancey. I mean, Miss Lucia, I'm sorry. All right.
Your
Do
Honor,
you
good
firm-
morning.
Good morning. How are you?
I'm doing well, thank you.
Good. Do you affirm that you will interpret from Spanish to English and English to Spanish with no extra embellishments to the best of your ability for the proceedings today?
I do.
All right, thank you. And Miss Lucia, this case is 26 CR 001043J with Nestor, Nestor Hernandez Dominguez. And he's charged with 1 count of criminal trespass, 2nd count of loiter and prowling.
Este va a ser el caso 26 CR 001043J. Es de la Fiscalía en contra del señor Néstor Hernández Domínguez con 2 acusaciones. La primera, perdón, es allanamiento de morada, traspaso criminal. Y el otro es vagabundeando.
And he has a second case, which is 26 FTA 001023. That is an FTA.
Y tiene otro caso, el 26 FTA 001023, que es por no haber aparecido, no haberse presentado en frente de, por una acusación.
All right, State.
Yes, this incident happened February the 15th of 2026 at about 12, between the hours of 12 a.m. and 12:17 a.m. at 1105 Holcomb Bridge Road in Roswell.
Sí, primero la juez pide escuchar de la fiscalía y le indican que este incidente ocurrió el 15 de febrero del 2026 entre las horas de las 12 de la madrugada y las 12:17 en el 1105 de Holcomb Bridge Road en Roswell.
Officers were conducting a business check at the Exxon gas station at that location and came across 2 individuals.
Los agentes de policía estaban chequeando un negocio en la gasolinera Exxon en esa dirección cuando encontraron a 2 personas.
They were hanging out along the back corner of the business, and the officers could smell burnt marijuana coming from the area in which they were located.
Ellos estaban en la parte de atrás del negocio y los agentes de policía podían oler marihuana de donde que venía el olor de donde estaban ustedes.
The officer spoke with the individuals because it was such an unusual time to have people located behind the building there. And they denied that they were smoking marijuana, indicating they were hanging out at the business and that they were, in fact, in that corner.
Las personas indicaron, estos dos individuos negaron que estaban fumando marihuana pero dijeron que sí, que estaban en la parte de atrás del negocio, nada más pasando el tiempo ahí, pasando el rato ahí.
It appeared that they had been given criminal trespass warning from May the 2nd of 2023, and that Ms. Shaw had also received another warning on April the 25th of 2024.
Parece que fueron dados ya una advertencia de allanamiento y traspaso el 22 de mayo del 2023 y la señora Shaw otro en abril del 2024.
Ms. Nestor gave consent to search his person where small foil packs along with smoking devices commonly used for illegal narcotics usage were located.
El señor Néstor dio permiso a las autoridades para que le chequeen, le revisen lo que cargaba en su cuerpo y encontraron paquetes pequeños de papel aluminio con ciertas otras herramientas para el uso de esta droga.
Ms. Shaw did not give consent to search her person, but they searched her incident to arrest once they determined they in fact had prior criminal trespass warrants, and they were able to locate on her several lighters, credit cards, smoking devices, foil packs, makeup, and other items in her bag.
La señora Shaw no dio permiso para que le chequeen sus cosas, sin embargo, ya que los agentes encontraron las previos órdenes de arresto por no haberse presentado antes, entonces la arrestaron, así registraron todo lo que tenían y encontraron paquetes de aluminio donde habían drogas, encendedores y otras herramientas y cosas que tienen que ver con drogas, aparte de maquillaje.
The current, he was given a bond of $10 for cash bond for each charge. And it appears that he failed to appear in court, which is why we're here today.
Le habían dado ya un bono de fianza para que saliera de la corte, para que saliera de la cárcel por $10 y salió de la cárcel, pero no se presentó a la cita de la corte, de la audiencia cuando tenía que hacerlo. Entonces por eso fue arrestado y está nuevamente aquí.
Your Honor, and we would just, I believe Ms. McLeod is asking for the FTA to be set aside or dismissed. And at this point, the state would say that there does not appear a reason in which to set aside the warrant or dismiss the FTA.
La abogada fiscal también indica que la abogada defensora tal vez ha pedido que le quiten el cargo que tiene por no haberse presentado a una audiencia anteriormente y la fiscalía aparentemente no está dispuesta a hacer eso.
And
Your Honor,
so, what are we doing today? This is not a plea. This is just a bond.
Yes, Your
right,
Honor.
Your Honor. I was hoping because this is his first FTA, and I have since filed a waiver of arraignment on his behalf. He missed his arraignment date. So I was asking, given that this is his first time, his first FTA, if the court would reinstate his bond so that he could get out of jail.
Y lo que la abogada defensora está pidiendo y está indicando que ya que esta es la primera vez que usted tiene una orden de captura por no haberse presentado a una audiencia, que le dejen, que le quiten ese cargo, el cargo de no haberse presentado y le dejen salir nuevamente. Eso es lo que su abogada defensora está pidiendo.
And as far as his criminal history, I understand this is first arrest, no history, pre-trial?
No, Your Honor, there is a 2024 conviction, yes. There's a 2024 conditional discharge for possession of methamphetamine. And then I also show a 2023 conviction out of Fulton for criminal trespass. And there's the 2026 FTA, a 2024 FTA, and a 2019 FTA of Hall County.
Okay.
La jueza pregunta si es que tiene antecedentes y le dicen que sí, que tiene, que le encontraron culpable en el 2024 por posesión de metanfetaminas, en el 2023 en el condado de Fulton por allanamiento, traspaso nuevamente, y de ahí tiene órdenes y nuevamente por no haberse presentado del 2023, del 2024 y del 2019 en el condado de Hall.
All right. And the state, your position is?
He missed a court date, and so our position is that it should not be set aside at this time. And I think Ms. McLeod made a different argument that she may want to reinstate in this case.
Yes, Your Honor. I'd prepared a waiver of arraignment for my client, but it seems for some reason it didn't get filed. I have since filed it, but when I was preparing for this, then I realized that was what happened. Had I filed that waiver of arraignment, he would not be in the position that he is now. So I feel like I am somewhat responsible for that having happened, because had I actually filed the waiver of arraignment, which fully had been my intent, he wouldn't be sitting in jail. This charge that he has, Your Honor, it's not a violent charge or anything, and he has no significant criminal history. And that is why the bond was set the way it was, Your Honor. And I'm just asking the court to reinstate the bond so that he can get out of jail and properly address this charge.
Well, he has two FTAs, 2024 and the 26th one.
That was why he was given the cash bond, Your Honor.
La jueza le pregunta a la fiscal cuál es la posición de ella. La fiscal indica que usted no se presentó a la audiencia, entonces estaba bien y que se debe enforzar la orden de captura por no haberse presentado a la audiencia. Su abogada defensora alega que ella pudo haber ingresado un documento a los tribunales para que usted no estuviera en la cárcel. Entonces lo que ella le pide a la jueza es que le vuelva a dar la misma fianza o le quite esta acusación de no haberse presentado a la audiencia para que le dejen salir bajo los términos de la fianza previa.
So if his FTA was lifted, then the two $10 cash bonds would be reinstated or would come back. Is that?
That is correct, Your Honor.
Well, usually I don't do that when they've had a prior, when it was in 2024. He's also had a prior conviction for criminal trespass as well. I think it was 2023, right?
La jueza indica que esta no es la primera vez que usted no se presenta a una audiencia en donde usted tenía una situación, que ya tiene eso, que ya ha pasado 2 veces antes. Aparte, tiene otra convicción o otra vez que le encontraron culpable por allanamiento y por traspaso.
Yes, that's correct, 2023.
Mhm. As far as work or contacts, what does that look like, Ms. McLeod?
Your Honor, I have to speak with my client to make sure that I have the proper contact information for him. So this does not happen anymore.
Y la jueza pregunta si es que tenemos toda la información donde comunicarnos con usted, dónde encontrarlo, y la abogada defensora indica que ella necesitaría hablar con usted para que usted nos dé toda la información de dónde se le puede ubicar.
And I guess the question is, and maybe we could ask him, Miss Lucia, does he work or have a job?
Yes, Your Honor. Señor Domínguez, ¿tiene usted trabajo? ¿Trabaja usted?
Sí,
¿En dónde?
en el roofing comercial.
And could we also ask him about make sure he has a good contact address so that he doesn't miss any more court appearances?
Okay. ¿Usted trabaja para una compañía o para una persona?
O para mi tío,
Ok. ¿Dónde vive usted?
en Roswell, ¿pasa la dirección?
Sí, ¿se la sabe?
Sí, es 1456 Ray Street Drive,
No, ¿me lo puede deletrear?
es 1456 Puerta G, los apartamentos se llaman Elliot Roswell.
Ya. Espéreme. Elliot Roswell.
Sí.
Give me a second, Your Honor, please.
If you could write that down for me, so because I
Give
want
me
to
a
make sure that
second.
I get
Give me-
it.
Yes, Ms. McLeod, give me a second. I just first need to understand what he's saying when he gives me the road. Me dice que es en el 1456, la puerta G de gato.
Sí, sí, sí.
Y de ahí se llama Raintree Way.
Yeah. Sí, sí.
¿Sí? Y eso es en Roswell y el código es 30076.
Perfecto.
¿Cuál es su número de teléfono?
No me lo sé, discúlpame.
Ya, ¿y se sabe el número de su tío?
No los tengo en el teléfono, pero no me lo sé. Perdón.
¿Dónde vive su tío?
Ahí vive con nosotros,
Él vive con ustedes. Okay. Your Honor, what he's telling me as far as where he lives, he's given me the address and I can put it in the chat or send it to Ms. McLeod. He also says that he does work. He works in commercial roofing with his uncle, and his uncle actually lives in the same place at the same address, same apartment.
And he's 29 years old or 30?
¿Tiene usted 29 años o 30?
No, tengo 27.
He's 27 years old.
I mean, 27, okay.
And could you ask him to provide a good telephone contact and email if possible?
I asked him about the telephone. He doesn't remember it. It's on
Okay.
his cell phone. ¿Tiene correo electrónico?
Sí.
¿Cuál es?
Es Néstor Alberto Hernández 05.
Espéreme. Néstor Alberto
Hernández 05 @gmail.com.
Okay. All right. I do have an email for you.
Okay, great. If you could send it to me in an email, that would be perfect.
Okay, Ms. McLeod, I don't have your email address.
I'll put it in the chat.
Okay, thank you.
You're welcome.
All right, just trying to see if he has enough contacts and things of that nature for this bond. And I will go ahead and ask that or order that the FTA be removed. We've got new contact information and that his bond be reinstated.
Thank you, Your Honor.
El fallo de la juez es que le van a quitar el cargo de la orden de captura por no haberse presentado a una audiencia. Los citatorios de la audiencia se le va a mandar a esta nueva dirección. No puede faltar, tiene que presentarse a los citatorios de la audiencia.
And let him know to contact his attorney when he gets out, and he can call the court to inquire and keep up with his upcoming court dates as well.
Okay. And Your Honor, just to clarify, when you say contact his attorney, you want him to contact Ms. McLeod?
Yes, me.
Correct.
Por favor, comuníquese después de, le van a dejar salir de la cárcel, tiene que comunicarse con su abogada, esta señora, la señora McLeod, después de, una vez que salga, y es su responsabilidad suya, de usted, chequear con la corte una vez a la semana, una vez cada 10 días, para ver cuándo es su próxima audiencia, por si acaso no le llegue el correo o alguien más recibe el correo. La corte no va a recibir eso como una excusa. ¿Y sabe comunicarse cómo comunicarse con la señora McLeod después? Ok, comuníquese con ella apenas salga. Okay, Your Honor, I did confirm that whether he knows how to get in touch with Ms. McLeod. He said he did. And I said, okay, as soon as you leave, then you need to reach out to her.
All right.
Thank
All
you.
right. Thank you.
Ms. McLeod, I have not seen your email on the chat.
Oh, I sent it. Oh, I sent it. That's weird.
Hold on. Oh, my bad. I had to look somewhere else. I
Okay.
found it.
You have it? Awesome. Thank you.
And will Ms. McLeod be submitting that order regarding the reinstatement of the bonds or set aside?
Yes, I will submit the order.
Thank you.
You're welcome.
Send that to Ms. Champion, I believe.
I will, Your Honor.
All right. Thank you.
Your Honor,
You're
if that
welcome.
is all my business with the court, may I please be excused?
Yes, you may. Thank you so much.
Yes, Your Honor. Have a good day.
All right. You too. Bye-bye.
Good morning, Judge. How are you?
Good morning. How are you?
Good, Your Honor. I just wanted to let the court know, maybe we have a request to hear a case that's on the 11 a.m. calendar. Ms. Berry, Michelle Berry, she's there on Zoom. She is a social worker at Georgia Regional, and she has a meeting at 12:30, but this is in regards to Mr. Stelly. He is number 16 on the 11 a.m. calendar. And like I said, Ms. Berry is there with Mr. Stelly to help him on Zoom. And if we can do his case pretty soon, Ms. Berry has a 12:30 meeting shift.
Okay. All right. We'll try to accommodate it. And
Thank you. I'm here at the courtroom all morning.
minutes. Okay. All right. How many do we have left?
Quite a few at ACDC, Your Honor.
Oh, boy. We take that first with the social worker and then come back around.
Yeah, and we can
If
finish.
everyone will indulge me. Yes. All right. Mr. Bartels,
Yes, ma'am.
can we take that real quick and then I can get back to finish up and then circle back?
Okay. Let me get a chair, Your Honor. There's this.
All right. Thank you. This is 26 CR 0019991A. Is it Darcy Stelly?
It's pronounced Darcy Stelly, ma'am. How are you, Your Honor?
Darcy?
Yes, ma'am.
Darcy Stelly, charged with 1 count of criminal trespass.
Yes.
So, yes, Your Honor, Mr. Stelly, this is his 88th day in custody. And we did get an evaluation done. And then after that evaluation was done, Mr. Stelly was hospitalized and he's doing much better now. And we're advised that he can go ahead and proceed. Your Honor, the staff at Georgia Regional, they have reconnected him with his family in California. That's what his support system is. And his intention after he is discharged is to retain whatever property he has and then go to California and seek services there and reconnect with his support system. And given the amount of time that he spent in jail, which, this is his 88th day in custody, and given the nature of this charge, he was just accused of being at a friend's home and he did not leave when the friend asked him to leave. So the state has made an offer of time served. I've relayed that to Mr. Stelly. Given all the facts and circumstances of the case, we would ask if the court would first consider a dead docket on this case.
Any objection from the state?
No, Your Honor, we're not.
Okay, all right.
Okay, thank you, Judge. I can prepare an order and I'll get that over today. Should I send that to Ms. Champion?
Yes,
Yes, ma'am.
that is
Okay.
correct. All right, we will do the dead docket. Good luck to you, Mr. Stelly.
Thank you so much, Judge Mincy. God bless you and take care.
Good
All
luck.
right, thank you.
Thank you, Judge and Ms. Evans.
All right.
Mr. Bartels.
Okay.
Take care.
All right. And who do we have next?
Next is, come on down, position 28 and 29.
Okay. This is Hunt, Betty Jo Hunt.
So, Your Honor, we
Uh,
still don't have an offer on this case.
Oh,
And I've still not drafted an offer on this case. This is a case in which, we have been looking at certain cases that are public safety cases that we have identified and are not offering until we've had contact with the victim. Hunt. Let's see. Oops, wrong calendar. Yes, and I reached out again yesterday to see if we could have come in contact with her, and we've not been able to speak with the victim for today's hearing, so there's no offer being made at this time. We'd ask that the case be reset based on our making efforts under Marcy's law to communicate with the victim, who has a right to be noticed as to every proceeding of the case and under the Crime Victims' Rights Act.
all right. So this will be reset to next week. Which will be, what will that be, June the 25th? Ms. Champion?
Yes, ma'am.
All right, thank you. All right, next.
Probation day too? Your Honor, is the probation gonna be handled that day too?
I'm assuming.
Okay,
Should be.
thank you.
All right.
Position 52 through 59. Miss Shelton.
Is this still going to be a plea?
Yes, Judge. Negotiated plea.
Okay. First case is 25 CR 0054028. Theft by shoplifting, simple battery, terroristic threats and acts, theft of lost or mislaid property. 25 CR 007275H. Ms. Shelton, in that case, is charged with theft by shoplifting, 54, which is case number 25 CR 0079428. She's charged with criminal trespass. And 26 CR 0031968, one count of theft by shoplifting. And 25 CR 0031978, charged with one count of theft by shoplifting and giving false information. Oh, I'm sorry. And one more case is the 26 FTA ending in 908. And that should be all. Well, nope. Do I have one more? I'm sorry, two more. And with the 26 FTA ending in 908, there's another FTA 26 ending in 909. And then the last position, 26 FTA ending in 9110. That should do it. All right. Those are all the cases for Miss Shelton. '52 to '59. All right. State.
All right, I'm sorry. This is just like reading someone else's handwriting at times. You're reading someone else's recommendations. Okay, so this is how I understand the plea. Hopefully that's the way that you all understand as well. As to count one, it is 12 months. All right, so as to count one, it's 12 months served, 365 days, credit for time served. As to count count two, it is credit for it is time served. As to count three, it is time served. As to count four, it is time served. So, and then position number 53 is consecutive to the case 25 CR 0054028H. And it is to be complete an anti-theft course and a social worker visit for MHBHET. As to count three is to run concurrent, 12 months probation, and to stay away from Foster, Bintu, Brianna, Chambly at the Aldi's located at 4670 State Route 138 in Union City. As to number 55, it is 12 months probation. It runs concurrent with the other cases. It is to stay away from Walgreens at 4617 Jonesboro Road. As to 56, it is 12 months probation to run concurrent. As to count one, stay away from the target at 3660 Market Place Boulevard in East Point. And as to the giving false information to an officer, it is time served. And the state would ask that she stipulate to identity, venue, and a factual basis for the plea. That plea is a total of 24 months 365 days to serve, credit for time served. The remaining would be for her to complete the anti-theft course, a social worker visit for mental health and BH issues, stay away from Foster Bento, Brianna Shamley Aldi's at 4670 State Route 138 in Union City, Walgreens at 4617 Jonesboro Road, at Target at 3660 Marketplace Boulevard in East Point, and the state would move to Null Pros, the FTAs in positions 57, 58, and 59. Thank you.
All right. Is that your understanding? PD?
Yeah. Yes, Your Honor. Defense stipulates the venue, factual basis, and ID. And with 2-for-1 credits, that works out to about 6 more months of time in jail for Ms. Shelton, less any time that she's already done in custody, and that will be credited towards that. And then if she understands the rest of the terms, and she knows she has to be on probation until she gets to 24 months. That was our understanding, and we'll move forward with the plea colloquy.
All right. And Ms. Shelton, I understand that you wish to plead guilty to all of the cases and charges today, with the FTAs being dismissed or no pros. Is that correct?
Yes, ma'am.
Okay, I'm going to, these are cases 52 through 59, which I've already read, trying in the essence of time, since this is a global plea to all of these, to give you the plea litany, and then I will ask you go down the list as to each charge after that you are pleading guilty to make sure we're clear, okay?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol that would hinder your understanding at this time?
No, I'm not.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you do understand that if you're currently on probation, it could be affected by the guilty plea here today?
Yes, ma'am.
And do you offer the guilty plea to all the charges that I'm getting ready to read to you? Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, I do, ma'am.
All right, as to the first case, and that is the case ending in 402H, how do you plead to the count of theft by shoplifting?
Guilty.
Simple battery?
Guilty.
Terroristic threats and acts?
Guilty.
And theft of lost or mislaid property?
Guilty.
All right, to the second case, ending in 275H, how do you plead to the one count of theft by shoplifting?
Guilty.
Right, as to the case ending in 942H, how do you plead to the one count of criminal trespass?
Guilty.
And as to the case ending in 3196H, how do you plead to the one count of theft by shoplifting?
Guilty.
And as to the case ending in 3197H, how do you plead to the one count of theft by shoplifting?
Guilty.
As to the one count of giving false information?
Guilty.
How do you, all right. And the others are the FTAs, which will be dismissed. Now, you do understand there are a lot of conditions, a whole lot of conditions. So I hope that you are prepared and agree to do this. The biggest things is staying away from these various places, Walgreens, Target, the marketplace, Walgreens and Target again in the marketplace. I think is that they're all at the same location. Is that correct, counsel? The Walgreens and the Target in Marketplace Boulevard in East Point, all of
No.
those.
They have different addresses
Oh,
for each one of them. And
well, it looks like I'm gonna just say globally, stay away from all Walgreens, all Targets while you're on bond for the 24, while you're on probation for the 24 months. Walgreens, Targets, and Walmart, is it those three places?
Aldi.
And Aldi.
Yeah,
So,
Aldi, Walgreens, and Target is what I have.
okay, Aldi's, Walgreens, and Target. So just stay away from all of them in Fulton County and maybe you won't have any troubles. Usually I give those particular addresses, but there's other stores that you can go to get the same items and purchase the same items. So I want you to stay away from those that you have had those charges at. Is that clear?
Yes, ma'am.
All right. Good luck to you, and we will accept your guilty. Yes, ma'am.
So what is the total of time that I have to do in jail? Or do I get time? Did I get time? And then I got time served for it?
Well, you're getting credit. I think your attorney read that and stated, you can state that again to her, PD.
Yes, Ms. Shelton. So the global offer is sentenced to 365 days. However, because Fulton County jails do 2 for 1, really you will be doing 6 months. And from that 6 months, you need to subtract whatever time you've already done in custody. You've been here since you had 27 days as of June 12th, and then add 6 more days. So 6 months minus those days, that's how
Okay.
much time you have left in custody.
Okay. Thank you, sir. Thank
All
you.
right, thank you. All right, you're welcome.
Next is position 17 and 18, Miss Edwards, Trinity Edwards, 17 and 18.
All right.
This is going to be a bond argument, Your Honor. I'll start with the bond argument.
Okay. This is position 1723 CR 0065888A, Trinity Edwards. Charged with 1 count of willful obstruction, 2nd count theft by shoplifting, and position 18 is the 26 FTA ending in 1043. Do I need to hear the pretrial? Have you all pulled the history?
Yes, Your Honor, I have. She has 3 cycles total. She
Hold
has
on a
an
second.
active warrant.
You're
Oh,
going, hold on. I'm getting every other word. Start over. Maybe it's not. Let's see.
okay.
All right. Start again.
She has
Okay,
3
that's better.
cycles. She has 3 cycles total. There is an active warrant listed on the GCIC, but I assume it's for the FTA that's on the calendar.
Mm-hmm.
I'm sorry, for the FTA that you already have. And then there is another FTA in 2026 out in February, out of Fulton. So the one in June and then the one in February. Nothing further.
Oh, so those are the cycles, no convictions.
Correct.
Okay. Okay. Thank
And
you.
Your Honor, I think the June FTA is this one that's on the calendar.
Right. All right. And go ahead, state.
Yes, Your Honor. This incident arose from an incident back in October of 2023, where John Hardy of South Fulton Police Department indicated that he was advised by Walmart loss prevention manager that there was video footage of 2 women inside the store concealing and stealing items. one of those being identified as Trinity Edwards, and a juvenile. They pushed past Mr. Wilson, lost prevention, and fled through the parking lot on foot. The officer observed the juvenile running through the parking lot, was able to run towards the juvenile and detain her, brought her back to the police vehicle, conducted an outerwear for weapons, and placed her in the vehicle. He indicated he walked to the other side to remove an item, which was an air fryer, from the back seat. And while doing so, Miss Edwards ran towards the vehicle and opened the back door of the police vehicle, yelling, "Come on, twin." He was able to push her back, the one that had already been detained, back into the vehicle, secure the door, and then detain Miss Edwards. She was in the video footage. It appears that she was wearing a pair of slippers worth $15.98 that she had stole and fled the scene with, because she was barefoot. She said she was barefoot when returned to scene. She was then transported. The bond was a signature bond that was given in the case of $1,000 signature bond as to each count. It appears that there was a plea and arraignment on May the 21st of 2024, in which she missed. Thereafter, she was arrested. The case was placed on the SAP calendar for February 26th of 2026. She waived arraignment, and the case was reset. Further notice. There was a plea and arraignment on June the 1st, which she missed, and that's why we're here today on that warrant. Yeah, as far as the warrant being set aside, and given a bond, the state's position that it should not, because this is actually 2 times in which she's missed her plea and arraignment. It's her responsibility to notify the court if her address changes in the interim, which is part of her bond conditions released.
All right. PD.
Thank you, Your Honor. My client is 21 years old. She indicated to me that she has been an Atlanta resident for the past 11 years. She's currently looking for a job, and she's also homeless, Your Honor. She's looking for housing. She also tells me that she's working towards a commercial driver's license. She's also working towards her GED. She goes to school at the at-premise center. That's where she wants to get her degree. She's seeking to get her son back, who is currently in DFACS's care. And Your Honor, she's not able to afford the $4,000 bond that's keeping her here. She's requesting the bond to be modified to the lowest possible amount, the lowest amount that's reasonable. And I'd like Your Honor to consider the request for the motion for bond modification.
All right. She's been in jail how many days?
I think she's been there for
6 hours. You ready to go back?
I have on this FTA, she was arrested and booked on June the 9th. We have 10 days that she's currently been in jail.
Okay.
Based on you're looking at the jailings from
jail
Odyssey.
screen. And then the breakdown is just 2,000 on each charge for the 4,000. Is it a surety bond that she's under now, or was it?
Let me look again.
Okay.
So, she has for the FTAs,
Mhm.
she has 2,000 each on that, so it's a $4,000.
And what was her original bond? It was the same,
No,
2,000 on each? Oh,
no, it wasn't. Her original bond was 1,000 signature bond on each.
okay. All right, since I don't, um, see any, convictions at this time, and the cycles are the FTAs, I will give her a chance if she will, follow follow the bond conditions. So what I will do is give her $4,000, we're going back through the signature bond again, $4,000 signature bond. I was thinking about putting her on pretrial, just so that there would be some monitoring per judge. 2,000 with each charge, $4,000 signature bond through pretrial. Level 1. And I think she's to take theft course. Believe pretrial has a theft course. No drugs, alcohol, weapons, or guns while on bond. And she is to stay away from, I didn't write it down, is it the BP gas station that she needs to stay away from?
I did, yes, well, hold on a moment.
It's the one.
It is Miss, oh, I thought I heard Miss Champion talking.
It is, the store is, Walmart. Walmart is the store at 1105 Research Center, Atlanta. I would ask that it be
This is Trinity Edwards, correct?
Trinity Edwards. She had an
Okay.
obstruction charge and a shoplifting charge.
Right. Okay. Gotcha. I was just making sure I was on the
Yes, and it
right
was at
case.
Walmart. Mhm.
Okay. Stay away from the Walmart. Do we want to say all Walmarts or just the Walmart where the incident occurred?
This was from 2023, so I would say the 1105 Research Center. I'm not sure if it still exists.
Yeah, it is.
Okay. Not from Fulton.
That's off of Cascade.
Okay.
So that Walmart off of Cascade on Research Center, you to stay away from that Walmart.
And
Obviously
Judge,
not.
I
Go
would
ahead.
ask that this be at a level 2. This I mean, this was the second time that she failed to appear for court, so.
Okay, I will do a level 2. Stay away from the Walmart and no drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else, counsel?
No, Your Honor.
All right, thank you.
Okay, Your Honor, let me get clarity on this for position number 18, which is the FTA. We're gonna set aside the FTA and then we're gonna issue a pre-trial bond for position 17. Is that correct?
That is correct. You got it.
All right, thank you.
Thank you.
For the litigation manager, I'll be sending a bond modification order. Do you need me to send anything for the failure to appear charge?
Yes.
I guess.
Or I guess that the
also-
bond modification would be for the failure to appear charge.
Yeah.
Right, because you're gonna do an order to,
Right. Correct.
Listen to me. Who do we have next?
Okay. Next is position 61, was it Watkins? Ms. Watkins, 61 and 62.
Okay.
And we still don't have an offer on this case, Judge.
State, what are we doing?
I'm gonna check an email, but this is still again another case, and they're here for an FTA for failing to appear on the case. Hold on. Your Honor, we would ask for a 1-week reset. We're going to have to actually go out to the house on this particular case to contact the victim since we've not able to reach them by phone or email or letter at this point. So we just have to make that last effort. We'd ask for a 1-week reset to notify the victim. To give him an opportunity to be present. It is a battery family violence case. So I can't, if he's going to do a non-negotiated plea, we're going to have to, or a blind plea, then we'll have to, make the offer at the maximum amount that is allowed by law.
Your Honor, if the state's not willing to give an offer now and is seeking a 1-week reset, my client's in custody only on the failure to appear on a $5,000 cash bond. So, I mean, she'd be sitting here for an additional week because the state hasn't had contact with their victim or with their witness, and this case has been going on since August of last year. I'd like to move for a bond modification and request a signature bond. I can go over my. But we can hear from pretrial and from the state first, but I'd like to move to modify your bond to a signature bond.
All right. How long, what was the arrest date on the FTA? The calendar
My
says
notes say-
June 12th, but I'm not sure.
It was
My notes say
June
June
the 1st. June the 1st is what it says.
Oh, I see, June 1st.
Mhm.
And today's the 18th, okay.
Yes, this case was scheduled for plea and arraignment on February the 23rd or 26th. And there was a waiver, so it came back up on the calendar May the 21st of 2026, which the defendant failed to appear.
Right. And pretrial, you have the history?
There's no prior history, Your Honor.
No history? Okay,
No prior.
thank you.
I can tell the court too what the original bond was. This was a split bond. it looks like, case
Okay.
originally, and that history is correct. There was a 1,000 surety on the simple assault and a $3,500 pretrial release. How the bond was set for the FTA. And so you just want to get modify the bond on the FTA? For
Right,
this,
because the
yeah, for
FTA, is that pretrial recalling on 3,500 or no? Or just not appearing? Well, I guess both.
It just says $5,000 cash bond, so
On the FTA?
on the FTA.
Okay. All right. Anything from you, PD Chataya?
Yes, Judge, some background information on Ms. Watkins. She's 54. She has been a lifelong resident of the state of Georgia, but she's lived in Atlanta since the 80s. She had 2 jobs before coming to jail. She was working at the airport. She had been in food service for over a year there. She also worked at a UPS facility scanning packages and operating the belt, and she had been doing that for 6 years. And she's also a high school graduate, Your Honor.
All right.
Did you need any factual basis from the actual charges?
Something minimal.
Okay, then this was the case in which I'll just read this warrant, just the This happened in August of 2025 at 845 North Central Avenue in Hatfield. This appeared to, it may be an apartment, not an apartment, a hotel or something of that nature. But they responded there. The victim is Robert Tarver, who indicated that he was afraid because she had a knife, a kitchen knife, during the heat of an argument between them. He was able to grab the knife from her and prevent any further incident, and that they had been in an intimate relationship for almost 9 years.
Okay. All right, and your request, PD, is for?
It's for a signature bond, Your Honor. Otherwise, the lowest bond amount that's reasonable for the FTA that was converted to a $5,000 cash bond.
I will order, and I'm looking originally, she was on a $4,500 bond. So I will order $5,000 surety bond. Stay away from the incident location, no further contact with the victim. No drugs, alcohol, weapons, or guns while on bond. And do I need to break that down, Ms. Champion, or you'll just split it in half?
Yes, ma'am, please.
Just 2,500 each.
But I thought that the bond was for the FTA. The FTA is
Sorry.
the charge that's keeping her here.
Yeah.
I'm forgetting we're not on a different calendar. My brain is still on last night, I think. I'm sorry, 5,000 surety on the FTA. I apologize. I was thinking something different.
Raise your hand if you want to say something.
I'm sorry.
Yes, is this a question for me, Ms. Watkins?
Yeah. Cause I turned my.
Okay, Ms. Watkins, I'd rather have Deputy Milton call me by phone and we can talk on the phone later, okay? Because I don't want you to say anything in court about the case or anything.
Okay. After this one, fine, we'll call him. Have a seat there, please.
Okay,
Next
and
is
hold for an announcement, Judge, on whether this is a plea or if we're resetting or anything. So just hold for an announcement.
Okay.
63 and 64, Miss Williams. Thank you.
This is a negotiated plea, Judge.
Okay. This is 24 CR 0074444C. Miss Denisha Williams charged with cruelty to children in the third, 2 counts of battery, family violence, 1 count of reckless conduct, and then 64 is the FTA, 26 FTA ending in 1039.
Yes, Your Honor, as to count 1 is time served. As to count 2, it'd be 12 months served, 30 days, credit for time served, balance probated. No further contact with Daza Williams. Complete 8 anger management classes. Stay away is not needed because the victim has moved out of state. 40 hours of community service. That's a stay away from the residence. It's still a no further contact with the victim. 40 hours of community service or a fine of $400. As to count 3, we would commute to time served. And as to count 4, it would merge into count 2. Stipulate to identity, venue, and a factual basis for the plea. And for the FTA, we would move to null pros that case.
Defense stipulates to all of the following, Judge. And I'd also like for Miss Williams to have the option of doing either the 40 hours community service or the $400 fine. She's not sure which one she'd be able to do, but I'd like her to have both options while on probation if that's possible.
How do we have both options? I'm not sure.
So if she either does 40 hours community service or pays the $400 fine, she'll fulfill that requirement to do one or the other.
Miss Champion, can we say it that way?
Well, without $400 fine, she will be committed to paying the $400 fine plus surcharges unless she goes back before a judge to get it modified to commute to community service.
Right. I don't think we can put or on the sentencing sheet, right?
Or in the system when it goes out for GCIC.
All right, Miss Williams, would you rather do the 40 hours community service or pay the $400 fine?
What will be like my time frame I have to pay the 400? Because I need to make sure I get back to work.
You'll get all of probation to do it, so you have the entire year that you're on probation to pay the fine. You don't have to pay it right away.
Okay, yeah, I pay the $400.
Okay, then we'll go with the $400 fine.
Okay.
The $400 fine plus the surcharges, so it's not going to be exactly 400. It might be close to 700.
Yes.
Okay. All right, so you ready to take your plea?
Yes.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. We're gonna ask you a series of questions. Make sure you understand your plea. Are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No.
Are satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you do understand that if you're on probation, it could be affected by a guilty plea today.
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
And so as to the charge of cruelty to children in the third degree, how do you plead?
Guilty.
As to the charge of 2 counts of battery family violence, how do you plead?
Guilty.
And as to the charge of reckless conduct, do you plead?
Guilty.
All right. That's
Judge, for clarification, the 1 count of battery family violence would merge.
Oh, I see. So there's only 1 count. Yes, thank you. I see it now. All right. So there's 1 count of battery family violence. How do you plead to that?
Guilty.
All right. All right. And you understand your conditions, correct?
Yes, ma'am.
All right. Thank you. Good luck to you.
Thank you.
Mm-hmm.
I'm gonna call Mr. Shatai now. Come on, you have a seat.
All right.
Yeah, come on, man. Okay. So I think we finished this course. I'm gonna log on to your course. Make it. No cool. I agree with what you do.
And who do we have? What are we doing? Mr. Bartels, you want to take some in between? Not for sure what we're doing.
Yeah, he's Mr. Bartels, he's coming up.
Okay, thank you.
Yes, Your Honor. Well, while the court reporter is still here, I think we have one negotiated plea on the 11 a.m. calendar. That would be Mr. Navy. He is number 14, Judge. And then also Mr. Madry, who is number 12, I think. Yeah, Mr. Madry is number 12, and that's going to be a bond request. So whichever the court wants to do first.
We can do the bond request on 12.
Mr. Madry. Okay, so Your Honor, this is Mr. Madry. He doesn't have anything else holding him in. The charges are trespass and disorderly conduct. Mr. Madry, and the reason for this bond request, Your Honor, is that he has some pretty urgent medical issues that might not be getting addressed in the jail. If you could look up towards, yeah, Your Honor, I don't know if the court can see it. It's very evident in his booking photo, but Mr. Madry has a medical condition with his right eye that's causing him to go blind. And I did speak with his mother. Annette Madry. He gave me her name and phone number. She did confirm that he's been diagnosed with a vision loss in his eye. He needs surgery and medications for his eye. And he tells me, and his mother told me as well, that this incident arose when he was at Grady getting medical care for his eye. He does deny the allegations that are in the warrant, which is basically that he allegedly refused to leave and was cursing at staff. He does deny that. However, he was at Grady for medical treatment. He said, and his mother confirmed, that he was scheduled for surgery on his eye on June 4th, but that did not happen because he's been in ever since, I believe, June 1st. He said, and he showed me the paperwork, he's requested medical help from the staff here at the jail for his eye. He's supposed to be getting eye drops and medication. He indicates that he's let them know about that need, but that he hasn't gotten that yet. And he's been in for 18 days so far. And I'm told that the vision loss in his eye is progressive and that his need for treatment is pretty urgent. And I think, you know, there's some doubt as to whether the healthcare staff at the jail are able to provide what he needs. So based on all that, Judge, we are obviously we're asking that he be able to get out and address this medical issue. Right now, it looks like he's got a $1,500 bond on each charge. And I've looked at his record in Fulton County, and you know, he does have a record. It's not terribly extensive. The only case is he's got a couple of open cases, one from earlier this year. It's just another trespass case from Grady. And then there's a disorderly conduct case from about 3 years ago. That's his entire recent history, Judge. So based on all that, we would ask if the court could consider a signature bond. If not, his mother indicated to me that she could likely post a low cash bond. We would consider, if the court's not willing to do a signature bond, we would ask the court to consider a $5 cash bond on each charge. There is a service charge that the jail charges in addition to the bond amount. But if he got something like a $5 cash bond on each charge, his mother likely would be able to post that for him. And that's all for now.
All right. State.
Yes, Judge, he does have some prior cases, including convictions for criminal trespass, which is why we were asking. He has 4 cycles out of New York, 52 cycles out of Georgia. And I guess the pretrial officer can maybe provide a more detailed criminal history, but it looks like on June the 1st, it is one of those cases in which he was told to not be, only in his previous case from February of 2026, in which he's out on bond on that case. He was told to only go to Grady for medical care, to go there, get his care, and leave. He was asked multiple times by the officer at Grady Security to leave, and he went on to state, "I'm not going anywhere. You're going to have to lock me up." So as a result of that and his failure to move on after he received his medical treatment, they charged him with remaining on the property after having received notice to leave the property. So the bond recommendation, I'm not sure what it was then, but based on his history, was set at $1,500 surety for each case. And I know that there's a $5 cash bond on the other case, which is from February of 2026. For the same location, similar circumstances, not willing, moving on after he gets his treatment.
So you all are wanting to continue with his 3,000 surety?
Yes, Your Honor.
And he's how old again? Mr. Majory is how old? Mr.
I've
Bartels?
got, date of birth is December 24th, 79, so he would be 46 years old, or yes, 46 is what I've got. Is that correct? Yes,
Yeah.
And he resides with his mom?
that's correct, Your Honor.
And then,
go ahead, State.
no, I was just gonna say that our history, just to see that those 52 cycles, I guess the convictions that she listed within the last few years was 2021 probation violation, 2021 disorderly conduct and criminal trespass, 2022 battery family violence that was amended to a battery, and a 2023 probation violations. There were 2, 2023 disorderly conduct and another probation violation. And then there were, at the time of this incident, there were 3 open criminal trespass cases, 1 ours, 1 Gwinnett, and 1 DeKalb.
Mr. Bartels, I'm concerned. I'm very concerned about his history and these open cases.
Well, as I said, Your Honor, I did look at his history. It did not, I don't think he had any, I did not see any felonies, although I don't have access to the complete history. But of course, my main concern, Your Honor, is his health. I am told that he's losing the vision in his eye. I do have questions as to whether the NAVCare, the healthcare providers at the jail, are able to get that. He has not gotten any medical care. He's telling me, and he's been in jail for 18 days. And I think, given that is part of the reason for our request, I would hate to see him, lose vision entirely in one eye. I do remember a couple months ago, there was a press conference here at the jail about another individual who hadn't gotten the medical care that he needed. That resulted in a substantial settlement. That sort of thing is not unheard of, and that's my main concern right here, Judge. And we would ask the court to take that into account.
Well, he's been pretty busy in the last few years with, and I'm very sympathetic to the medical issues and his vision, but he's been picking up cases in spite of that. That's my concern. I'm assuming if his health gets worse, I guess he won't be able to get out to commit these other offenses. But I just wish he didn't have such a concerning history to be able to do this. And I can understand why the state is concerned. The state doesn't want to consent or do this because of the history that we have. Well, I tell you what, I will modify the bond, and on each of those charges, I'll do a $50 cash bond on each, which will be $100 total.
I appreciate that, Judge. I'll write an order and get that to Ms. Champion today.
And then those same conditions, again, he needs to stay away from Grady unless he needs treatment, or he needs to find somewhere else to go, because they should not have to be subject to, this kind of treatment trying to help him. So if he can't contain himself, he needs to go somewhere else and still not, be abusive or disorderly to the staff there.
Okay, I will certainly include that as a condition, Judge. Thank you.
All right, thank you.
Mr. Bartell, when should we reset his case if his mother can't make the bond?
I would say a 2-week reset, Ms. Champion, that would be the July 2nd. Yeah.
Okay, thank you.
Thanks for reminding.
All right. Thank you, Ms. Champion.
And the next case, Your Honor, is Mr.
I'm
Dave.
sorry, and if he intends to enter a plea, would you not want to put both cases on the calendar?
That's fine, yes.
Okay.
And a brief announcement on position 61 and 62, Sandra Watkins, that's going to be a reset to the next calendar.
Okay.
Any questions? No. Ready to get out of here. No.
All right. Reset to 6/26. Okay.
Your Honor, that calendar 6/25 has over 7 pieces on it, so it's gonna have to be July 2nd, Mr. Chicago.
Is this full?
All right.
Okay.
I'll speak to her about that. And Your Honor, those are all the cases I had on the calendar. May I be excused?
Yes, you may. Thank you.
Thank you, Your Honor.
All right. This is Mr. Is it Stelly?
This is Mr. Navy, Your Honor. He is number 14. And it's a negotiated plea.
I'm sorry, that was incorrect. Now I have it. Position 14, Jacob. Is it Navy or Navi? How do you pronounce it?
Navy.
Navy. Okay. 26 CR 003520C. 1 count of Lauder and Prowl. State.
Yes, Your Honor, it is 12 months served, 30 days, credit for time served, balance probated, complete the Operation 21 law and decision making, maintain his MH, no further contact with Artie Yanley, and stay away from the 640 Linwood Avenue address. We did have opportunity to speak with the victim in this case, and he is fine with it as long as, you know, he maintains his that MHET status there.
So just a question, Ms. Evans-Battle. The maintain MH, that basically means get the evaluation and whatever treatment they recommend.
Correct. Correct.
That's our understanding, Your Honor. We would just ask that the court accept the agreement and that the court consider waiving 1 month of probation fees or letting probation go not reported once Mr. Davies is done with the class and the MHET.
Does the state have any objection to him going non-reporting?
No, Your Honor.
Okay, I can waive 1 month of the probation fees when he can go non-reporting once he's completed the conditions.
Thank you, Judge.
All right, and so Mr. Navy, I understand you wish to plead guilty, is that correct?
Yes, ma'am.
All right, raise your right hand for me so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol at this time that will prevent you from understanding?
No, ma'am.
All right, are you satisfied with the services and the representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And you do understand that if you're on probation, it could be affected by the guilty plea today?
I understand.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, as to the charge of loitering and prowling, how do you plead?
Guilty.
All right, I will accept your guilty plea and you understand your conditions, correct?
Yes, ma'am.
All right. All right, good luck to you.
Thank you, Judge.
All right, thank you.
And those are the only pleas or hearings we have, Your Honor. Just the rest of the 11 a.m. calendar is just status.
Okay. Go ahead.
So we want to start with the 11 a.m.
Yes.
May I have your first name, Mr. Bartell?
Yes, Paul.
Thank you.
Your Honor, I'm sorry. Are we done with the SAP calendar for today?
I hope so. Let's see, deputies, if anyone tells me otherwise.
Your Honor, can we go over the SAP calendar before we start, please?
Thank you. I'm such in a hurry that I was leaving you out. I apologize.
And then I believe there's also a single person on the DD bench warrant calendar.
Right, I see that as well. And there's a couple that I don't have things I know Ms. Champion will get us straight here. Go ahead, Ms. Champion.
Position number 1 and 2 is going to be reset to the SAP 625. Position 3 and 4 is reset further notice jail jury. Position 5 is reset further notice. Position 6 is a null pros. Position 7 is a null pros. Position 8 is reset further notice. Position number 9, 10, and 11 are reset to the SAP July 14th. Position number 12 was a plea. Position number 13 was a null pros. Position number 14 was a plea. Position number 15 and 16 was pleas. Position number 17 is reset further notice. Position number 18 was reset further notice with a set aside. Position number 19 is reset to the SAP 625. Position number 20 is reset further notice with a bond modification. Position 21, defendant was released, reset further notice. Position 22 was a plea. Position 23 was null pros. Position 24 was a plea. Position 25 is reset further notice. Position 26 is reset further notice with the set aside. Position 27 is going to be reset further notice jail jury. Position 28 is reset to the SAP 625. Position 29 is reset to the SAP 625. Position 30 is reset further notice defendant release. Position 31 reset further notice defendant release. Position 32 is going to be reset to the SAP 7-2 with the additional cases. Position 33 is going to be reset to the SAP July 2nd. Position 34 is going to be reset to the SAP June 25th with the additional case. Position 35 is reset further notice. Position 36 is reset further notice with the amended bond. Position 37 is going to be reset to the SAP 625. Position 38, 39, 40, 41 are going to be reset to the SAP July 2nd. Position 42 is reset further notice jail jury. Position 43 is going to be reset further notice jail jury. Position 44 was a plea. Position 45 is reset further notice jail jury. Position 46 is reset further notice jail jury. Position 47 and 48 is reset further notice jail jury. Position 49 is reset further notice defendant release. Position 50 is going to be reset further notice jail jury. Position 51 was a plea. Position 52 was a plea. Position 53 was a plea. Position 54 was a plea. Position 55 was a plea. Position 56 was a plea. Position 57 was a null pros. 58 was a null pros. 59 was a null pros. Position 60 is reset further notice defendant release. Position 61 and 62 will be reset to the July 2nd SAP. Position 63 was a plea. Position 64 was a null pros. And position 65 and 66 is gonna be reset for the notice jail jury. Any questions?
No, ma'am.
The add-on.
You had to add on.
Add-on is Mr. Orr. We had two positions, gonna be, reset. Reset for the notice.
Yeah.
It's gonna be reset for the notice jail jury. And that, add on with that bond modification is reset for the notice with the, bond. I think Mr. Jordan is handling that case.
Yes, I think I've already signed that one.
Any other questions?
Nope, I don't. Anyone else?
No, thank you.
No,
Thank you.
Now we can move to the, is the DV defendant on the line? Do we know?
I don't
He,
know.
got arrested on the warrant. So
Our car?
he already got arrested on the warrant, so his case is gonna be reset for the notice.
Okay, he's already been arrested, so it's reset for the notice.
All right, thank you.
Thank you. Your Honor, that's all I have with the court. May I be excused?
Yes, you may. Thank you for a long day. All right. Okay, Ms. Evans Battle. We're gonna need Friday and Monday off.
Yes.
Yeah, we do
I called it myself, giving the other attorneys a break and said, okay, just clean up your cases. And I
Right.
did email after email, you have to email on top of it, so.
Right. So you haven't got no break and no rest for the weary.
I am going to put my feet up for a minute when we get out of here.
Right. Yes.
Yeah, that will be nice.
Right.
I'm just gonna take it.
That's what you have to do, and don't answer the phone.
Yeah, no good deed goes unpunished, like they say.
Ah, there you go. That's a good one, Mr. Bartels. Yes. All right. What else do you have? Is
Well, yeah, Your Honor, I'll just start with number one. Ms. Chambers,
YouTube.
number 1, 2, and